Yes,
What's if I'm defending if item 4 can be possible for the future?
item.
4. I want to find a shop at my work.
Why today only?
I don't know about that, my lord. I have this matter in court too, my lord. I'm so sorry to mention about this, but my learned friend, I did not know that this matter was like there, and my learned friend is already here from Gauhati in court too. So,
Mr. Sankenga, the learned counsel appearing on behalf of the petitioner submits that on account of some matter, other matters, he is busy, for which the matter stands adjourned to be listed next week.
I give you that. Please mention. I'm going to be asking questions in countries. The most item 21 and 22. Now, in item 22, we were to find the discernment of national.
Hmm?
In item 22.
Ah,
In item 22, I need to reply to them.
so the pleadings are not complete. So we reverted back to admission stage now. It can't go to the hearing stage.
And there's another issue. In relation to the applicability of the 65C Act and the 30 Civil Act, the matter has been led by the Indian bench and Judgment Reserve. That will also have a bearing on this case.
I am of the view that if the judgment is reserved, it would be better for me to pass the order so that it may also aid the division bench. Anyways, you want time for 21 and 22. What do you say, Mr. Iralu? No problem.
Well, you really require, I'm just okay,
But it's a matter.
I'm appearing in 21, my lord.
Okay, what do you say, Mr. Advocate General?
My lord, if he wanted time, he would have mentioned it to us a day or two earlier. Anyhow, that would have been fair.
Mr. A.G. Momi, the learned counsel appearing on behalf of the petitioners in WPC number 50/2020 and WPC number 204/2021. Mr. K.G. Balagopal, the learned senior learned advocate general, appears on behalf of the state in WPC number 50/2020. Mr. Iralu, the learned senior counsel, appears on behalf of the respondents. Respondents in both the matters, no? In the private respondents in both the matters. Mr. A.G. Momi, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would like to file an affidavit in reply. So taking into account the above, list this matter again on how much.
My lord may keep it in June, preferably before 17th of June or 16th June. I'm there at that time also.
On 16th of June 2000.
I'm grateful. I'm grateful.
In the meantime, the reply be filed on behalf of the petitioners on or before.
And
15th
advance copy be given to us, my lord.
by providing advance copy to the respondents. Yes,
Worship on behalf of Mr. Two James Mountain, AG, item number 5, actually. This one after reaching court, he has still health complications. So if they
Yes,
that's tomorrow.
On the way to court, so it'll be tomorrow. Last week it was tested twice, but the letter could not be taken up. But if priorities came tomorrow,
we can start today
I have no problems. If we start.
and finish it off when Mr. Imsong comes. This matter came up on Monday last and again on Friday, but on account Tuesday and Friday. But on account of the fact that I couldn't do the matter in view of Mr. Joe's matter, so therefore the matter got adjourned.
Yes.
So what do you say? Or we'll try our luck tomorrow.
So my respectful prayer, if this is taken up as far as I can now, we take out the supplementary flows, we can make it priority. So if this is the case, there's an emergency is get.
I think.
Yes.
We do one thing. As Mr. Takamasa submits that there is a urgency, we grant you an adjournment day. But tomorrow, any government advocate can appear. Mr. So-and-so, the learned counsel appearing on behalf of the state, submits that on account of that Mr. I am Song, the learned additional advocate general, had some difficulties today. This court duly takes note of that this is the third time the matter has been listed in the span of 7 days. And as such, and Mr. Takamasa, the learned senior counsel appearing on behalf of the petitioner, submits that there is urgency. Taking into account the above, list this matter tomorrow at the top of the list after the motions, if any, and the motions, if any. So in the meantime, if it is difficult on the part of Mr. Im Song, the learned additional advocate general, to appear on behalf of the state shall engage any other counsel from its panel to appear on behalf of the state.
Yes.
Yes.
Actually, I think you mentioned I remember now. I know the petition has dealt with fractions. This is pertain to the question of notice for selection of the voting. And in the magic of this petition, the selection has been completed and order has been issued.
So in
So
your,
already been told with the religious right.
okay, so order has been issued in your favor.
No,
So therefore, it is a separate cause of action.
yes, sir.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the present petition the present petition cannot be proceeded with in the present in its form, taking into account that in the meantime, a selection have already taken place. And the selection and the results have been announced.
Selection from election.
Election have already taken place, and the results have also been announced. He therefore submits that the petitioner may be permitted to withdraw the instant writ petition without prejudice to the petitioner to again approach this court, challenging the selection of the election, the results of the selection of the elections. Mr. C.T. Jamir appears on behalf of the private respondent and submits that he has no objection on the withdrawal with liberty. Considering the above, the instant petition therefore stands closed on withdrawal. So it is observed that the withdrawal of the instant petition shall not prejudice or preclude and prejudice the petitioner to again approach this court, challenging the election of the selection, the results of the election and selection. If we have a golden ink, put his name, Mr. Peter. Yes. While I was about to sit, the registry asked me whether I will be in a position to finish up the matters so that I can accompany my sister to the new building. I said, I don't know. I cannot know because I don't know how long the list will go. But from the manner in which the mentioning is going on, I may have to write at 11. Yes.
Item 8. So, for the petitioner, instruction and my senior is not taking very well. So we are withdrawing about a month.
What?
We are withdrawing about a month.
Who is withdrawing the worker?
My senior is people and
First of all, Mr. P.V. Paul, he wants to withdraw. He has to submit. And you are there. You are withdrawing it.
Yes.
Have you informed the client?
Yes, we have this over the briefings.
When? He has taken over the brief.
Last week.
So we dismiss for default. None appears.
No, personally, we given to the petitioner to make sure.
He knows about this matter. He has taken in the brief.
No, Lordship, it's not the petitioner, but it's my senior's difficulty that we are not continuing to, so we're not going to continue.
Okay. Mr. Fong said up. Pote, the learned counsel appearing on behalf of the petitioner, submits that they are no longer instructed to appear in the instant proceedings, inasmuch as the petitioner have taken back the brief. He therefore submits that, taking into account their names have been reflected, he is mentioning the matter so that the matter can be taken up on any other date. Mr. Ajo appears on behalf of the private respondent.
3 to 6.
3 to 6, and Mr. So-and-so appears for the state.
Why would
So, taking into account the above, the petition, the present with petition stands adjourned to be listed again on 25th of June 2026. In the meantime, Mr. Ponset of Pote, the learned counsel, shall duly intimate the petitioner about the date so fixed, so that on or before the next date, the petitioner is in a position to engage some other counsel. Yes.
I've taken a position of the party, I help with the related duties on for.
Which one?
I think free. Not feeling too well, so
Huh?
they said it's not feeling too well, so it's
Who is not feeling well?
the last phone.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that he is not feeling well, for which he seeks for an accommodation. The counsel appearing on behalf of the respondent objects and do not object to the same. Consequently, when will you feel well? No, absolutely no. You can't get well so soon. We'll have it again after vacations. 15th of June. So this week, all your matters will get adjourned. Okay.
Mr. Lordship, I get to mention item number 12 and 13. Here I have received the written opposition filed by the state respondent. So can we allow me some time to go through the affidavit also, if necessary, outline the plan.
The counsel appearing on behalf of the petitioner submits that the affidavit in opposition of the state have been received by them only recently, and therefore would like to obtain instruction as to whether the petitioners in both the petition would like to file any reply, and if necessary, would like to file reply. Accordingly, list this matter on 27th of July 2026. In the meantime, liberty granted to the petitioners to file any reply.
For motion, item number 1.
Your Lordship, to this petition, the petitioner was requesting direction for respondent number 5. She is the designated inspector under the Nagaland Management Sector 2005. Investigate the complaint which has been filed before this authority. My Lord, the petitioner borrowed an amount of 30 lakhs in the year 2022. For that 20 lakhs, till the month of March 2025, the petitioner has already paid an amount of 80 lakhs. Despite the payment of such huge amount, the money lender is asking for another 65 lakhs 23,000. So for that reason, complaint was lodged under the money lender sects. The relevant paragraph is relevant pages before your own. Complaint was filed on 2nd of July 2025, and it was duly received on 5th of July 2025.
This
It
is
has
a
been
7-5.
only months.
7-5, they have received it.
Yes.
Until now, they have not taken into account.
Yes. Many times the authority has been advised about the complaint, but no action is being initiated.
But Mr. Counsel, how can this court pass an order without the person who is against whom you are asking the complaint to be investigated is not made a party?
My lord, the act of 2025 empowers the investigating authority.
There's no quarrel with that. But the fact that that person is not a party against whom,
No adverse, my lordship. If
then
the action is being passed,
can we say then you investigate the complaint,
yes.
but don't involve that person?
No,
Can we send it? So tomorrow, would he not come up and say, "Hey, look here, you have passed this order without hearing me"?
this petition, my lord, is confined and limited to the official duty of the designated inspector. Now, in order to investigate, definitely the investigator can issue notice inviting necessary parties, and then the procedure can be upheld. Now, my grievances is the investigating authority who has been empowered to investigate is not doing anything.
Understood?
Now, this petition is only limited to that purpose, my lord.
So
Now,
you
in no way,
you are
only letter is
you are
preferred.
asking this court
Yes,
that you kindly investigate, issue the direction to the respondent number 2 to carry out an investigation. Against whom?
yes, the money lender.
And he is not a party.
Yes, because, my lord, this petition is because the mandate, the provision of the act is not being upheld.
But anyways, when this court directs,
Yes,
could he not be bound? Otherwise, that person may very well come up and say, now if you see today, a person commits a crime,
yes, my lord.
you can file an application before under the BNSS, isn't it? Isn't it the requirement of law that that person should be put to notice before issuance of process? Isn't it
The present scenario, my lord, is the police itself is not doing anything when money lending issues are involved. No FIR is being entertained.
so no FIR,
Yes.
if no FIR is entertained,
Yes,
then why you are not going to the parameteria provision of what section 175 of the BNSS?
my lord, section, the money lender said.
No, understood. He is violating.
Yes, yes.
It's a crime.
Mhm.
So BNSS should not apply the procedure.
At this juncture, my lord,
You have the BNSS.
it's not the my lord, I have.
Give him the BNSS. I think earlier 156, now it's 175 if I'm not wrong. Isn't it?
My lord, may I kindly address this honorable court that section 17 of the Money Lenders Act specifically provides that even the court cannot take cognizance unless the designated inspector find the written complaint.
Understood. So therefore, written complaint before whom? After investigation.
Yes, my lord.
So therefore, if he is not taking up an action,
Yes,
read 175, what is it?
police officers power to investigate cognizable case. 1. Any officer in charge of the police station may, without the order of the magistrate, investigate any cognizance which, upon having jurisdiction over the local area within the limits of such station, will have power to require into or.
This is as per 156.1 earlier. Earlier. Then you have 156.2 is 175.2. Now let us come to 175.3.
1 said, but to any magistrate involved under section 120 may, after considering applications supported by an affidavit made under subsection 4 to section 173, and after making such inquiries of things necessary and submission made in this regard by the police officer, such an investigation as above mentioned.
So here you say that the police needs to investigate your complaint.
There is only number 5 is that the designated inspector is extra assistant commissioner, my lord. It's not police official. So there's an embargo.
So it is not therefore the police.
Yes, this is not the police. The respondent number 5 is.
Let us see the act. Let us see the act.
Section 17.
Money Lenders Act.
Page 14. I expected the relevant paragraph. Section, hello? Page 14. Paragraph 17.
Now, who are the people who have been appointed? Who is the inspector under subsection 1?
Yes, now my lord,
Show me the act.
the notification. The notification is page 75, to which the relevant sections are section 7 and 12, my lord.
Issue notice making it returnable on 22nd of June 2026. Mr. Tiangami accepts notice on behalf of the respondent numbers 1 to 5.
My
The
lord,
petition-
Copy set, sir.
Extra copies of the writ petition be served during the course of the day. The petitioner herein is aggrieved by the action on the part of the respondent number 2. Who, respondent number 2? No, who is the inspector?
5.
Action on the part of the respondent number 5, who have been appointed as an inspector in terms with section 12(1), bracket 1 of the Nagaland Money Lenders Act 2005 in not proceeding with the complaint submitted by the petitioner as far back as on 27/5/2000. 27/5?
No, 2/5, 2/25.
22/7/2025.
Yes.
2025.
Up to 7.
27/2000.
Yes, 7.
Pusto. The learned counsel appearing on behalf of the petitioner submits that it is a duty, statutory duty imposed upon the inspector to carry out the necessary investigation in terms with section 12 and in terms with section 12 for violation of section 7 of the Nagaland Money Lenders Act 2005. The same having not been done, the petitioner has approached this court by filing the present writ petition. The respondent's hearing, and more particularly the respondent number 5, is directed to file an affidavit on or before the next date as to why no steps have been taken for the purpose of carrying out an investigation and then submitting a report before the concerned magistrate in respect to the complaint filed by the petitioner on 2/7/2025. First, taking into account that the person who is against whom the complaint has been filed is not made a party to the instant proceedings, the maintainability of the writ petition is kept open.
For admission, item number 2.
This morning, the public department, I filed my reply this morning.
Oh, then you have a copy of the reply? You have a copy of the reply or not? You have filed?
Yes, I filed this morning.
The respondents are not asking for a copy of the reply.
I served this
Are
morning.
you submitting that the difficulties, seeing the difficulties of them? They are to make that submission.
This morning I received the copy.
So you have no problem?
Yes, I'm ready.
Huh?
I'm ready.
See, they don't have any problem. You are.
If that is the case, let me know come up on the first login.
Why? They are ready. We can call for that or we can ask you for a copy. You must have 100% made 2 copies. Or Mr. Thom would also provide his copy also. Huh? After? After 2.
Yes,
Today.
yes,
What is the matter about? Land ownership.
yes. Lordship, in the meantime, in the third portion, in the particular life, who does respondent 6 instead of 5 party? So, I mean, I don't agree.
We will not look into those aspects. There is a stay? No stay. You are working?
I'm presently working as MTS.
I think I took up this matter earlier, didn't it? And I wanted to dismiss then. Came in the month of August. Oh, March. Yes. You are working, no problem then. The counsel appearing on behalf of the petitioner submits that he has filed an affidavit in reply today. The said affidavit in reply, however, is not on record. Considering the above, as the pleadings are complete, this court admits the writ petition and directs the writ petition to be listed for hearing in its usual course.
In the meantime, I will be able to make the necessary correction.
You can't. What is their correction?
Lordship, I inadvertently.
It will come after 2 years.
It should be responded.
You file an application, that is your thing. What do you want to say?
Portion in my third portion,
Respond number 6.
yes.
What do you want to say? Okay.
Uh,
And heard learned counsel appearing on behalf of the petitioner, and Mr. Itomi appears on behalf of the respondent, and so appears for respondent number 5. The learned counsel appearing on behalf of the petitioner submits that there has been a typographical error in the prayer portion of the writ petition, which is an inadvertent error committed by the counsel and not. And as he submits that in the prayer portion, the respondent, the prayer portion, the mention, the word respondent number 6, which is being mentioned, should have been respondent number 5. This court have also taken note of that in the instant writ petition, there are only 5 respondents, and the respondent number 5 have been appointed by the impugned order dated 26 April or July. 26? 26/4/2024. Everything mistake. And here you say 26 April, July 2024.
Yes, it's good.
Taking into account that it was a mistake committed by the counsel, this court permits the petitioner to make necessary correction by hand. The prayer portion. Thereby, the reference to respondent number 6 would be deemed as respondent number 5. And the reference to the impugned order dated 26th April, July 2024 shall be 26th April 2023. It is also being submitted. The petitioner, the counsel for the petitioner shall also make necessary changes in the writ petitions, copies of the writ petitions which have been served upon the respondents. This court also takes note of that an affidavit in reply has been filed on behalf of the petitioner, and the said affidavit in reply is not on record. The registry shall bring on record the said affidavit in reply and list the Further to that, as the pleadings are duly complete, this court admits the writ petition and directs the writ petition to be listed in the usual course for hearing. You work for another 2-3 years.
For admission, item number 6.
It's getting warm. Can you ask somebody to turn the fan and? Yes.
Let me stop you. On the last list, the executive chief empty that meeting.
Salary of the petitioner from the month of March
Yes.
is currently under process and is entitled to the salary with effect from so and so. At this stage, we will place that the matter may be listed after one so as to ascertain. Have you got the money?
No. Till today.
Since the payment concept, the state claims that the salary is under process, and the rest of the interdependent process is taking time. So direction may be given within a specific time period to comply the election.
Or pay interest, 18% to be deducted from the salary of that officer. Better. They do it very fast then. I've seen it in the principal seat. We passed that order. Yes. Didn't it? Get 10% interest.
There was discrepancy.
No, that question doesn't arise. A person you have been asked to work from July 2021 and you have not made the payment.
And your worship recently also.
PIMS, does this person concerned have any role in putting the name out there in the PIMS? No.
He was supposed to produce some documents.
He has produced it. Have you asked him? When did you ask him about the production of those documents? And if he has paid, and he has produced those documents. This is very bad. I think we passed that on.
Recently also there was some discrepancy was found in the petitioner, they were
This matter came up before me. The record reveals that the notice was issued on so-and-so, however, not to speak of filing an affidavit. Instructions have not been given. Taking into account this quote, the fixes on which date the respondent. From a perusal of the communication, it appears that there is a discrepancy in the credentials of the petitioner pertaining to date of birth in the PIMS vis-a-vis the Aadhaar card, and this discrepancy here. Keeping in mind, this quote fixes in here for an update whether the petitioner has been disbursed the salary from the month of so-and-so. You have, as of now also, you have not got.
Yes.
From the month of 2026 also, you have not got.
Yes.
Your worship were working on the branding salary as well, so it's for your worship if.
No. I think we call this person concerned. Who is that officer? We call him.
This may be important, your worship.
No, this is not
Your
important.
worship,
This is in violation.
Instructions recently.
I
your
can't
worship.
help it. We call this Commissioner and Secretary Works and Housing, Nagaland. Let him come over and explain why we should not initiate contempt against him. There's a specific order to make payment for March 2026. Why haven't you paid that? I'm not looking into all these things. And what is your problem is? You have given in emphasis on Aadhaar card. Even the Supreme Court today, on that day, categorically says that Aadhaar can't be used for anything except putting it in your wallet.
There was discrepancy in the PIMS and Aadhaar, so this had to be corrected.
The PIMS and Aadhaar, it is your fault. And does it take so much time?
Because there was some discrepancy, the father's name, the date of birth, the date of joining the service, your worship. So all those things had to be brought through and affidavit, your worship.
Huh? You
Yes.
submitted the affidavit.
Of course, it
Yeah.
corrected. Now PIMS, the discrepancy has been removed.
Then
And your worship, recently there was some discrepancy.
again you found some more.
Because there were two person named Haupen Home and there was on the same Aadhaar card number, they were issued different PIMS codes. So that clarification has been rectified now, your worship. And on that telephone, community have been informed that it's under process, your worship. It's with the department right now.
You should stop relying on Aadhaar. Aadhaar has no business. Aadhaar is not for citizenship, Aadhaar is not for voting rights, Aadhaar is not for anything. It may only be used in a hotel for the purpose of finding out what is your, that you are a Indian origin person. So it makes no sense. When are you paying? Friday? Friday? From March 2026. Remaining when you are paying?
You once that.
Or- No, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of the respondents. The petitioner herein is aggrieved by the actions on the part of the respondent authorities in not releasing the petitioner the salary from the month of July 2021. When the requisition came up before this court on 23/2026, on 17/3/2026, this court sought for instructions as to why the petitioner had not been paid the salary. On 23/2026, instructions were placed before this court to the effect that there were certain discrepancy in the credentials of the petitioner pertaining to his date of birth in the PIMS portal vis-a-vis the Aadhaar card. And this discrepancy have now been resolved and there is a direction upon the Chief Engineer PWDH to complete all necessary procedure, including his salary with effect from March 2026. First, taking into account the said submission, this court fixed the matter on 24/2026 and thereby directing the respondent authorities to release the salary from the month of March 2026 onwards. First, this court further observed that the entitlement of the petitioner for salary with effect from 2021 shall be considered on the next date. On 23/4/2026, when the matter was listed before this court, the learned counsel appearing on behalf of the respondents had placed before this court and in letter dated 9/4/2026, written by the engineer-in-chief in PWD Nagaland, Kohima, wherein it was stated that the salary of the petitioner for the month of March 2026 is currently under process and he is entitled to the salary with effect from July 2021. Under such circumstances, the learned court bench of this court fixed the matter today to have directed the petition to be listed after 1 month so that an update can be produced before this court as to whether the salary from the month of March 2026 onwards have been paid, and also as regards the area salary with effect from July 2021. Today, when the matter has been listed, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that till date the petitioner have not been paid a single penny. On the other hand, Ms. So-and-so submits that there are still certain discrepancies which requires to be resolved. This court have given an anxious consideration to the respective submissions, and it is seen that the respondent authorities have been delaying the entitlement of the petitioner for reasons other than bona fide. Considering the above, this court fixes this matter again on July 14th, 2026. In the meantime, this court directs the respondent authorities to release the salary of the petitioners with effect from July 2021 till from July 2021 till the current period on or before the next date. It is observed that if there is a failure on the part of the respondent authorities to release the salary within the time as per the aforementioned directions, this court would be constrained to impose interest upon the respondent authorities at the rate of 9% per annum from the date the petitioner was entitled for the salaries. It is further observed that in the circumstance the interest is imposed, this court is imposed, imposed upon the respondents at the rates so stated. The said amount shall be recovered from the salary of the erring officials. List accordingly. I gave you time, no more extension. 9%, and then you get the money from them, from the chief engineer.
For admission, item number 7.
Same order. Dash.
For admission, item number 10.
Madam, we put it in this manner that you direct you to pay, and I am asking you why I should not impose interest at the rate of 9%. then it will be better. Madam, you put it like this, huh? This court further observes and directs that on the next day, this court shall consider as to why interest at the rate of 9% should not be imposed upon the respondent authorities for payment of for delay in releasing the salary of the petitioners of the petitioner, and why such interest, if directed to be paid, should not be recovered from the salary of the erring officials. Better.
This question.
Yes.
We have received the affidavit just today inside the court, so
Then
yes, we may be given permission to go through and I'm for private number 5.
you serve it today.
No, the government received it only. Inside going to.
Huh?
We received inside the court today only.
From the government. And when did the government file it?
So if.
What is the matter here? Landowner ownership.
This one.
No stay.
Also,
Okay. The council, Mr. The government, the state of Nagaland has filed an affidavit in opposition. On Friday. You have not filed reply.
no, I just received this morning. I received this morning.
Have you filed reply to the affidavit filed by you?
No, it's not very yet. I mean, this week time or for anything.
No, there was a direction that there shall be no further adjournment granted.
The most official time of given to 25.
Then why haven't you filed it?
The petition was so special, so I could not get it straight in between.
Okay. The council appearing on behalf of the petitioner submits that he would have to inquire with the petitioner as to whether the petitioner would like to file a reply to the affidavit filed by the state. Because taking into account the above listed matter in the week commencing from July 2020, week commencing from 28th of July 2026. In the meantime, the parties shall take steps for completion of the pleadings.
So I will tell you to file reply to the respondent.
Didn't I say the parties shall take steps for completion of their pleadings?
Man.
Last one.
For admission, item number 11.
Raise that.
They have been corrected.
I told you. I've mentioned that notification also in my order. In this regard, this court would like to refer to the notification bearing number dated 30/4/2013. Okay, what is your case?
The suit was filed, I think, this one. Now, in the suit, there's only claims that the property was purchased after her marriage.
Now, what is the order passed? What is the trial court's order?
Trial was ordered that page 200,
Page
200,
100.
200.
200 is the trial court's order.
Yes. Trial court ordered at page 179.
That is what I'm saying. Trial court's order.
179.
120,
179. 178.
39,
178. Starts from 178.
yeah, 178. Yeah, this is the one, the matter. This is an application, 178 is your application. Oh, this is a order.
Yes, sir.
An application under so and so. What did you ask for? You are the plaintiff?
I am the respondent.
Okay. In view of the above, it is prayed that the IOs will be. So there was a direction, the injunction sought for to maintain a status quo.
Yes, sir. No, no. I was restraining from
Understood?
entering into this.
Not, you are trying to sell off. That is the allegation.
That is the idea. 187.
I hereby restrain from entering.
Yes, ma'am.
Who is in possession?
I'm in possession. She vacated on her own account.
Huh?
She vacated, the plaintiff vacated on her own accord in the year 2023.
Okay. Let's see her application.
Application.
Or plain.
Plain is at page 39.
59. Okay, plain. Of right title and interest of the plaintiff over the suit land bearing registration number so and so. Restraining from interfering with the occupation and possession of the suit land.
That's 16. The basis of the plaintiff.
The land is registered in whose name?
So the late husband's name,
Huh?
my late father's name,
Of the plaintiff.
the plaintiff's husband. I am the son. The plaintiff is my stepmother.
Okay. So the plaintiff husband had purchased the land.
Yeah.
And husband expired.
Husband's.
So plaintiff is in possession?
No,
Who is in possession?
son.
How?
That is me.
How are you in possession?
Because I have my own house there, in the same block. Marital home, where my late father and my stepmother are staying. And my home, which I constructed on the same block. In the year 2023, she of her own accord, after my father's demise, she left, allegedly various things, she left. But she left in 2023. Even after obtaining this interim order, she has not wanted to come back. But she's just fine with me.
Okay. Now, that is one.
Can you write your attention to the basis of the, in this claim? Your worship, can you see paragraph 16 on the plate? At page 49.
Yes.
Paragraph.
Her husband is a property dealer and has acquired lands in his name after they got
After they-
married. However, the defendant, whom the plaintiff's husband raised, not even son. You're not son.
I am an adopted son.
Okay.
I'm an adopted son.
Is making all efforts to sell the property and also threatening the plaintiff of dire consequences if the plaintiff goes against his wish.
The point, man,
Also came to know the defendant is trying to dispose of the 2 plots of land and her husband has purchased after they got married.
yes. So she claims that these properties were purchased after her marriage, but if not so. And her own documents, what she could say, page 61,
Age?
page 61,
Okay.
61. Page 61 and 62 are related. And what you see, this is,
When did they get married?
he got married 8/1/2021. And he expired on 28/8/2023.
Okay.
And you also could see in page 61. If purchased in the economic says, if purchased.
No, but whatever may be, the question is, she was the wife.
Yes,
There's no quarrel with this.
yes.
And as per the rights, she has a right over the land after the demise of her husband?
We are saying no.
No. As per the legally, as per the the Indian Succession Act,
Yes, yes.
will come within the Indian Succession Act or no?
Not politically, no.
Indian Succession Act doesn't apply. Normally Christians will apply, but here taking into account
Our customary practice.
10 years customary practice will apply. Now, if it is a customary practice, would the wife have a right?
No, ma'am. No, ma'am.
Where is it?
She can stay as long as she wants. But if she goes, she goes.
So you mean to say that the wife has no right?
Yes, my lord. Unfortunately, but that is the custom of most.
What is this tribe?
It's not right.
Huh?
Both are right.
Lothar tribe. The wife has no right.
No.
And that is why she is mentioning that this was married, this has happened after
Yes.
after her marriage.
Yes.
And the son has a right.
Yes, my lord.
And the son has been adopted.
The son is the younger brother's. The son is the late father, younger brother's son. It is an adoption within the family because the elder brother did not have any issue.
So you can adopt it.
Yes, ma'am. And he was 102 years old when he was adopted.
Now, does she admit in her plaint that the son had been adopted?
Yes, ma'am.
It's adopted.
Yes,
Now he wants
And that's
this,
that's the defense which has been set up. Not a natural son.
huh?
What the plaintiff is saying is that the defendant is an adopted son of the nations.
So it is admitted.
Yes.
So therefore, the question is, the trial court had passed an order not to enter.
Yes, sir.
You must be aggrieved only with that aspect,
Yes, ma'am. That is.
nothing else.
That is.
So we do one thing, we say that status quo as regards possession.
And let the all issues be decided.
Matter what? You are in possession, you be happy. There won't be a status quo, then he can't sell.
Well, His Lordship, during the pendency of the suit, the petitioner has sold some portion of the suit land.
No.
Huh?
The petitioner has sold some portion of the suit land, Lordship, and I filed an IA under over 100
Personnel
portion of the suit land.
sold it.
Yes,
So
And-
that is a different thing. I'm not on that. You order 39 rule 2A will be before that,
correct. Yes.
not before me. My question therefore is, as of now, whoever you have you said that you are in possession of all the 3 properties?
Your Lordship, I was just out on my home. I didn't went out on my own fruition.
But are you in possession of the property or not?
No, Your Lordship, I was staying there. But since
they threw you.
Yes, sir.
So therefore, what is required? You have to therefore ask for a mandatory injunction that you should be entitled to restore the property. But
Yes,
what plaint you have filed is the plaint say that for this thing, a decree restraining the defendant from interfering with the occupation and possession of the suit land. Page 53. Now, if you are not in possession, are you in possession? Where is your statement that you are in possession of the land?
Your Lordship, before I approach the trial court, I have approached the petitioner that since my husband has left 3 properties in his name, I have asked the petitioner to at least grant me one and take the remaining 2, but they didn't agree to it. And they have chased me off.
Mr.
Because of that,
Counsel,
I'm not in position. of-
Mr. Counsel, this will be decided by the trial, whether you have a case or not.
Yes, sir.
I'm only on the question as to whether the trial court rightly passed an order not to sell, have not permitted him to sell it. That order, I don't think, meets any interference. But without ascertaining that you are in possession, the court could not have passed an order, thereby asking him not to enter. And you are admittedly not in possession.
Yes. Paragraph 9, there's no skipping. Paragraph 9, but there is nothing like these ones. Next page.
Where?
In spite of all these, meaning that
Where? Page?
page 46. Page 46.
In spite of all this, the defendant and family were not allowing them to leave the house. But since the plaintiff's sister saw the suffering with the plaintiff defendant and his family members were inflicting on the plaintiff, they hesitated here. And the family, on seeing that they cannot stop the plaintiff's sister from taking the plaintiff, told them that until and unless they sign the paper, they will not allow the plaintiff's sister to take the plaintiff. The defendant and his family then drafted a note and forced the plaintiff's sister to sign on the note, failing which they cannot take the plaintiff with them, and even forced the plaintiff to sign on it, but she refused. However, the plaintiff signed on the note. It may not be stated here that the plaintiff's sister was forced and compelled to sign on the note, and so refused the letter, as they refused. Left with his sister, son, along with one of them, came to the place where the plaintiff and threatened the plaintiff to hand over the amount of rupees so and so only them. However, the plaintiff told
Just this one.
that she cannot hand over the amount to them without the consent. Also asked them to leave her alone, as they caused immense suffering to her while she was staying in her matrimony. So you are not, you are staying with your sister.
Yes.
Presently, I'm staying in my village, Lordship.
With your sister. Whatever maybe, that is what it is portrayed.
Yes, Your Lordship.
So we do one day, we otherwise maintain the order of injunction and direct that possession would be as regards status quo shall remain as regards possession. You are not there. If he is there, he is there. You are there, you are there.
No.
Because otherwise you can't stop him, but he cannot sell it. That remains. Okay.
Then, Lordship, in that case, I may be allowed to enter the premises of the Lordship. Because there is still one building which is not remain occupied.
But Mr. Counsel, for that, don't you think that you need to go to the trial court and file an application?
Your Lordship, if you could please turn to page number 60. If you could please turn to page number 60. Page number 60.
Yeah.
Your Lordship, this decision was made after my death has been expired. And on 39th of June, my family as well as the petition family, we sat together, and this was the agreement which was made. But in spite of this, they did not comply.
Mr. Counsel, all are understanding. But the
Yes, sir.
fact remains that if you are not in possession, you have to ask for a mandatory interim, mandatory injunction for insert in entering, which you have not asked. Now, what has happened? A person who is already there inside, the court said that don't enter. This is the problem. So, we therefore say that the person who is in possession shall remain in possession. As regards the other thing, there cannot be a sale of a properties which are the subject matter of the suit till the disposal of the suit.
No issues.
So I maintain that order that he can't sell it till the disposal. But as regards possession, whoever it is. Okay.
No issues.
Sure. This is an application file. Heard Mr. A. Jimomi, the learned counsel, appearing on behalf of the petitioner, Mr. So-and-so, who appears on behalf of the respondents. Numbers
For responding.
appears on behalf of the respondent. The petitioner herein is aggrieved by the order dated 22/8/2014, passed in IAC number 88/2024, arising out of title suit number 02/2024 by the Court of the Learned Civil Judge, Senior Division, Dimapur, whereby the learned Dimapur bracket, hereinafter referred to as the Learned Trial Court, whereby the petitioner herein his men, agents, servants, etc., were restrained from entering, disturbing, interfering, disposing of the suit land covered by registration number 6605, 1409 and 1717 during the pendency of the suit. The petitioner, being aggrieved, preferred an appeal before the learned principal judge, district judge, Dimapur, which was registered and numbered as Civil Appeal number 02/2024. The learned bracket before the principal district judge, Dimapur, bracket, the first appellate court, the learned first appellate court, bracket close. The learned first appellate court, by the order dated 31/2026, directed dismissed the appeal and it is under such circumstances the petitioner has approached this court by filing the instant proceedings under Article 227 of the Constitution. Before entering into the dispute, this court finds it relevant to take note of that the jurisdiction under Article 227 of the Constitution, 227 of the Constitution, is a supervisory jurisdiction which is circumscribed to be exercised, circumscribed by the settled principles and to be exercised only when it results when the order so passed by the subordinate court, by the learned trial court or the learned first appellate court within the jurisdiction of this court shocks the conscience of the court. Next. In the backdrop of the above, this court finds it very relevant to take note of the conspectus of facts which led to the filing of the instant application. The respondent herein as a plaintiff had filed a suit being titled suit number 02/2024 before the learned trial court. Seeking various declarations and consequential reliefs. It was the case of the plaintiff. It is the case of the respondent herein as plaintiff that she married. She was married to one M.T.S.E.N.K.H.O.M.O. Kikon. On 8/1/2021. It was the fair case of the plaintiff that unfortunately her husband expired on 28/8/2023. The respondent had further stated in the plaint that during the marriage, during the period when the respondent was married to her husband, late so-and-so, 3 properties which have been specifically mentioned in the schedule to the plaint were purchased. The allegation made in the plaint was the petitioner herein, who was the defendant in the suit, being the adopted son. Adopted son, no? Do you recognize?
He is claiming that he is the adopted son, but I'm not claiming.
Not?
In my
We say that the defendant herein claiming that he is the adopted son
yes.
have not only entered into the possession of the said premises, but also is taking steps to transfer the said properties, though the defendant do not have any right to do so. It is under such circumstances the suit was filed seeking declaration of right, title, and interest over the scheduled lands in favor of the plaintiff, semicolon. A decree restraining the defendant from interfering with the occupation and possession of the suit land, semicolon. A permanent injunction restraining the defendant his men, agents, servants from disturbing and interfering the peaceful occupation and possession of the building by the plaintiff, etc. It is, however, very relevant to take note of that though in the claim the plaintiff have sought for a permanent injunction that the defendant should be his men, agents, servants, etc. should not disturb and interfere with the peaceful occupation and possession of the building by the plaintiff. But at paragraph number 6, paragraph number 60, paragraph number 9. Paragraph number 9 of the plaintiff.
Yes.
Paragraph number 9 and 10 of the plaintiff, it is saying that the plaintiff have alleged that on account of the torture affected upon her by the defendant, she was compelled to leave her matrimonial home and reside with her sister. Sister, na?
Yes.
In her
Relative village.
native village. The record further reveals that the said suit was registered and numbered as title suit number 02/2024. Along with the suit, the plaintiff filed an application seeking ad interim temporary injunction, thereby restraining the defendant from entering, disturbing, interfering in the suit land during the pendency of the suit. In addition to that, the plaintiff also sought for the said application was registered and numbered as Miss Case number. Number is IAC 88/2024. The records further reveal that the respondents, the petitioner herein, who was the defendant, appeared and filed a written statement cum counterclaim. In addition to that, the petitioner also filed written objection to the said injunction application. The learned trial court, by the detailed order dated 22/8/2024, passed an injunction thereby directing the defendant oblique the petitioner herein, his men, agents, servants, etc., from entering, disturbing, interfering, disposing of the suit land covered by registration number 6605/14/1409 and 1717 during the pendency of the suit. The petitioner herein being aggrieved had approached this court, have filed an appeal before the learned first appellate court, which was registered and numbered as Civil Appeal number 2/2024. The appeal having been dismissed, the petitioner has approached this court. This court have duly perused the order passed by the learned trial court, as well as the order passed by the learned first appellate court. This court have also heard the learned counsels appearing on behalf of the petitioner as well as the learned counsel who appears on behalf of the respondent. In addition to that, this court have also perused the pleadings before the learned trial court, which includes the plaint, the documents relied upon with the plaint, the injunction application, as well as the written statement cum counterclaim and the objection so filed. From the materials on record, it is apparent that on one hand, the plaintiff, oblique the respondent herein, claims that she has title over the lands which have been described in the plaint, and on account of the actions on the part of the defendant, oblique the petitioner herein, her rights have been clouded. It is under such circumstances the plaintiff have sought for a declaration of her title in respect to the properties described in the schedule to the plaint. This court, however, duly takes note of that in the plaint itself, it is the self-admission on the part of the plaintiff that she had to leave her matrimonial home on account of the torture committed by the defendant. Under such circumstances, admittedly, the plaintiff was not in possession, physical possession, of the suit lands. The question therefore arises as to whether the learned trial court or as well as the learned first appellate court ought to have, a learned trial court could have passed the direction, passed an injunction, thereby restraining the defendant, oblique the petitioner herein, from entering into the suit land when the plaintiff, the petitioner, was already in possession of the suit land. In this regard, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Wonders versus Entox Limited, reported in 1990 Supplementary SCC 727, and more particularly to paragraph number 9, wherein the Supreme Court observed that the status quo as on the date of filing of the suit should be maintained. This court duly takes note of that it is the self-admitted case of the plaintiff that she was not in possession of the suit lands. However, she claims that she has a right over the suit land. Under such circumstances, it is the opinion of this court that the learned trial court ought to have maintained the status quo in respect to the suit land, so far as the title, the right, the title, as well as the possession, instead of passing an order, thereby restraining the petitioner, oblique the defendant, from entering into the suit land wherein he was admittedly in possession thereof. In the opinion of this court, the impugned orders passed by the learned trial court and which has been confirmed by the first appellate court amounts to an order passed which shocks the judicial conscience of this court, and also an orders which have been passed without considering, which prima facie appears to be perverse, as having not taken into consideration the vital aspect that the petitioner was in possession of the suit premises. This court also cannot turn a blind eye to the fact that a plaintiff have claimed right, title, and interest over the suit lands. And under such circumstances, If third party rights are being created in the meantime, during the pendency of the suit, it would lead to multiplicity of the proceedings. Considering the above, this court therefore modifies the orders passed by the learned trial court, dated so and so, which was confirmed by the learned appellate court with the following directions. A. The parties herein are directed to maintain status quo as regards the title and interest in respect to the properties in question, properties described in the schedule to the plain. The court, meaning thereby that neither of the parties herein are restrained from transferring, alienating, as well as encumbering the suit lands as described in the plain, schedule to the plain, in any manner whatsoever till the disposal of the suit. First. Next. This court further directs both the parties, further restrains both the parties from changing the nature and character of the suit land during the suit land so described in the schedule to the plain till the disposal of the suit. First. This court further directs that the possession of the suit land shall remain as on the date of filing of the suit. That is, the defendant, oblique the petitioner herein, would continue to remain in possession unless a court of competent or authority passes an order, thereby directing the handing back of possession of the suit land to the plaintiff. Okay, I give you that liberty. You file an application. Okay. With the above the petitions. After a long time, I'm doing a civil matter.
What's the next?
For admission, item number 14.
This is also. I filed my affidavit to reply this morning against the affidavit from opposition filed state respondents. They have said that my client, the petitioner, is a single side of the list to be considered for compassionate appointment. Now, my lord, no clarity is given as to when my client's term to come to lordship. Serial number 35, my client is already 33 years, my lord.
Hmm?
The petitioner is already 33 years.
Another 5 years is there.
Lordship, if we go by the state's office memorandum dated 17/9/2015, it says another additional of 5 years. So it perhaps it is up to 40 years. but-
Finally come to page 56.
Lordship. Hello,
57,
yes, Lordship,
clause 8.
yes, Lordship.
So you have another 5 years. 33 till 38 you can be choking.
Lordship, as of today, it's 35 years.
You are 35.
No, up to 35 years.
No, you see, upper age limit of the applicant under this scheme may be relaxed in exceptional cases up to the maximum of 5 years in addition to the existing relaxation, if any.
Lordship,
So,
presently it's up to 35 years, so with relaxation, it should come to 40 years now.
so you have time.
Yes, my lord, but serial number 35, so at least the state should come up with the explanation as to when the term of the petitioner is likely to come. Based on the incumbency, Mr. Lordship, that there is no clarity on that aspect.
This is which department?
The power department, Your Lordship.
Now, madam, tell me, you are a specialist in here. Why you are having, on one hand, you have a particular notification of 16/6/2006 or 16, wherein you categorically say that when you are appointing grade 3 and grade 4, you are going to have it district-wise. Then why you are having it in this manner? Different departments cannot have different area. Family, health and family welfare has different one. They have it by district. There has to be a uniformity. This appears to be wrong. Petitioner hails from which district?
From Zilliwater District, Your Lordship.
So Zunevato, here he will be number 1, 2, 3, 4, 5. No, not 5. 5, 6, 7. 7, na? Will be number 7. It has to be by district wise.
Lordship,
Then,
Lordship, then I think there's some like.
because you can't have it, you have separate departments saying different things, you cannot have it. That day there was this submission made. I approved it. That if you are doing it district wise, obviously you do it by district wise. But that, if that is so, then this is wrong. Then you cannot keep on changing it. What is that notification? Who appeared on that day? Mr. Longkumar appeared. Why did? Whom Mr. Longkumar noted? Mr. Angami, kindly ask him, Mr. Longkumar.
Lordship, since I visit the branches this morning, so it was this.
We will consider that otherwise, but this can't happen. Because on one hand, you categorically say that in view of that notification of 16/6/2006 or 16, all direct recruits who have to be made in respect to grade 3 and grade 4 would be done as per the inhabitants of the districts. That is your law. And that is the basis on which you say that it should not be district all over similar. Every department cannot have a different thing. So you give an explanation why you want to do it like this when this court have already passed an order now.
She paid this letter of valid. Well, I will go through that.
The affidavit is not concerned. Mr. Seki, are you relying on your affidavit? No.
No, I just want some clarification and my lord has gone the same version. Let him explain.
But there has to be done something. They cannot be separately.
Redemption. Not represent same thing by the department is.
Heard Mr. J. Seki, the counsel appearing on behalf of the petitioner. Ms. So-and-so, who appears on behalf of the state of Nagaland. The petitioner herein is claiming benefit in terms with the office memorandum dated 17/9/2015 for appointment on compassionate basis. The said office memorandum do not stipulate in which as to how the list is to be arranged. However, taking into account the addendum dated 9/4/2019. 9/4, na? The list for appointment on compassionate basis in terms with the office memorandum dated 17/9/2015 is required to be made by taking into consideration the person who had expired earlier, irrespective of when the application is filed. This in the instant case, the petitioner, the respondents have filed an affidavit wherein they have mentioned that the petitioner is at serial number 35 of the list of the waiting list of applicants for the compassionate appointment in the order of death as on 29/9/2025. This could have perused the said list, and on a perusal of the said list, it is seen that the said list has been prepared for all the districts together. This court finds it relevant now to take note of the office memorandum dated, yes, Mr. Longkumar, that day you produced one for health and family.
Yes, Your Lordship.
Which one?
I can't recollect the date of that. It's about miscellaneous enactments.
That was item number 3 on Friday.
I wish I would.
It was a meaning elusive. Because dated so and so. Whereby it is categorically mentioned that in respect to the direct recruitment post, in respect to while appointing on direct recruitment to grade 3 and grade 4 post, the same has to be done by taking into consideration the local inhabitants of the district. The office memorandum dated 17/9/2015 makes it further clear that the appointment on compassionate basis has to be made for only for grade 3 and grade 4 posts. And the said appointments also has to be made from the direct recruitment quota. This court have also taken note of that different departments of the government of the Nagaland are adopting different approach while preparation of the list. In the case of Health and Family Welfare Department, it is done on the basis of the office memorandum dated so and so. It is done on the basis of district wise. Whereas in the instant case, which is the power department, it is being done taking all the districts together. a submission on a submission. This court also finds it relevant to take note of the judgment passed by this court in the case of so and so versus so and so. That is on Friday, dated so and so, wherein this court had clearly upheld the decision of the respondent authorities to prepare the list for appointment on compassionate basis district-wise. This court is also of the opinion that the state of Nagaland, for the purpose of implementing the office memorandum dated 17/9/2015, has to have one approach, meaning thereby that different departments in the state of Nagaland cannot be permitted to apply different yardsticks. This, if allowed, the same would go against the very fundamentals of administrative law, that the state should speak in one voice. Under such circumstances, this court therefore directs the respondent authorities to apprise this court as to why. To apprise this court by filing an affidavit as to why a different yardstick has been adopted in different departments of the state of Nagaland for making the list for appointment, for consideration of appointment on compassionate basis. The Chief Secretary of the Government of Nagaland, being the authority in this regard, is directed to file an affidavit and explain the position of the state of Nagaland in that regard. List this matter again on 23rd of June 2026. In the meantime, the Chief Secretary, Government of Nagaland, is directed to file an affidavit in respect to the aforesaid query made by this court.
For admission, item number 15.
Yes. Annexure?
Annexure A of application. This is a representation to the Deputy Commissioner. To direct the village council to issue a certified copy of the judgment passed by the village council. To enable the petitioner to approach the appropriate authority.
Then
Then again subsequently, the petitioner by annexure B, page 24, the high copy is checked.
legal notice.
Okay.
Then
So here, legal notice was issued to the Deputy Commissioner to pass appropriate order on the earlier representation passed by the application. Now, instead of passing appropriate order, the Deputy Commissioner is to the matter to the provisions. Then provisions took up the matter as a normal suit and passed judgment. Against that, the petitioner filed and appealed before the Deputy Commissioner, the Deputy Commissioner appealed. Now, my
31.
case here is, yes,
under 31, you filed an appeal.
yes,
Then
131. Now, my case is under the rules. The petitioner has to file an appeal before the Deputy Commissioner. The petitioner did not file any appeal before the Deputy Commissioner. That what the petitioner applied was for a direction, because the Deputy Commissioner is supervising administrative authority of the villages to pass a direction to the village council to issue its judgment.
But why did you participate in the?
Your lordship, when the law is clear, that when the law lays down service procedures to be done in a certain manner, it has to be done in that. Subsequent proceedings cannot just validate that. That is my case, your lordship. If I agree your lordship to chief of this or the
No, you see, are you saying that the Dobasi court did not have the jurisdiction?
no,
Why?
because the Dubai case and the village councils, they have primary jurisdiction.
So,
Your lordship.
but why
Now,
did you participate?
Your lordship, I may participate, but it has to be a case filed before the Jubilee Commission. There was no case
No,
filed before the
It is
Jubilee
not
Commission.
required. You may very well ask for disposal of a matter and show me the book, the rules of justice.
1937 rules.
23A. What is 23A?
23A says that the Dubai ships henceforward shall drive.
Henceforward shall try and decide such civil cases
cases.
only as may be referred by them
Yes.
to them by the deputy commissioner here.
Yes.
So,
Civil
in terms with 23A, the Dobasi
The
decided.
Dubai ships can take up a civil case referred to it by the Jubilee. It's not question. What I am saying is, I did not file any civil suit before the Jubilee Commissioner. For the Jubilee Commissioner to refer it to the Dubai ships. It is
No.
not, and it is also
No,
not
no,
an
no,
appeal.
no, no, no,
Your
no.
lordship,
No.
it is also not an appeal.
Here it does not say civil suit.
Yes,
Civil case.
civil case.
Civil case is
The
different.
civil case, it is not a civil case, your lordship. Because if your lordship goes into my representation,
Then why did you participate?
your lordship, my participation does not, because your lordship knows very well that there is no estoppel against law. I will participate, but if the initial proceeding itself is illegal, then it is not a thing I don't know. That is what I am stating before this honorable court. I will take your lordship to the judgment. If your lordship is satisfied, the lordship may consider it. First, I will take you to 2011 5 SEC 142.
What does he say?
Paragraph 32 and 33, okay? Paragraph 32, which was also evaluate. It is a set of legal proposition that if legal action is not in consonance with law, subsequent proceedings would not sanctify the same. In such a fact situation, the legal maxim so and so is applicable, meaning thereby it gets a foundation is removed the superstructure force. Now, with regard to the
Why haven't you filed an appeal on the 31?
your lordship, yes.
File it before the district judge. Isn't it?
Yes.
No, file it before the district judge. Go there. Or file a suit, whatever. May be. File it before the
Yes,
district
but there
judge.
is this, that which has already considered should be set aside, otherwise they would apply it. That is one case. One has already.
No, you have participated after getting the order.
My participation, your lordship, the law is very clear, my participation does not validate the subsequent proceedings, very much, right? If your lordship may allow me to take your lordship to 2011 10 SCC 714. I'll just take your lordship to
Well, first one, I'm not satisfied.
2011 10 SCC 714.
Page,
714, para 32.
32.
Yes.
Yes.
32. It is settled law that when any statutory provision provides a particular matter for doing a particular act, the said thing or act must be done in accordance with the manner prescribed. Therefore, in the act, merely because the parties concerned were aware of the acquisition proceedings or served with individual notices does not make the position altered. When the statute makes it very clear that all the procedure modes have to be strictly complied with in the manner provided therein.
Not
That is-
applicable.
That is one aspect. Then the worship on board as with regard to 1984 to 16. This is with regard to no installment in the law. Paragraph 38. Paragraph 38. Lastly, it was found good that by the council for respondents that the appellant would keep stopped from challenging the mechanical process because he did not oppose the introduction of this process, although he was present in a meeting personally or with his agent. His argument is wholly undeniable because when we are considering a constitutional or statutory provision, here there will be no strong against such title. And whether or not the appellant agreed or participated in the meeting which was held before introduction of the working mentions, if such a process is not permissible or authorized by law, he cannot be stopped from challenging the single law. That is my. So
There
here,
is, Mr. Council, that's estoppel.
it's over, yes.
We are
Now
not,
here,
we are not on estoppel.
Your lordship, maintainability means.
No, we are not on estoppel.
Maintainability means, yes,
Mr.
your lordship.
Council, we are not on estoppel, we are on waiver.
Your lordship, if the deputy commissioner has applied a procedure which is not there in law, is that not,
No, you have waived,
I have,
you have not estoppel. It is a case of waiver and acquiescence.
your lordship, waiver and acquiescence, whatever, no estoppel. That means there, I cannot be stopped from challenging it subsequently, although I have participated.
You can
Your
very well
lordship,
challenge, there is no quarrel with that proposition, you can very well challenge it out there for the district judge. Not here.
Your lordship, if this lordship may set aside the judgment, earlier judgment, which is illegal, and allow me to approach the appropriate court, that is, I am ever ready. But without that, if this illegal order is.
You
not
want to go
fulfilled,
with a clean slate,
It has to be, yes. And
and they.
the deputy commissioner has to direct the village council to issue me the order so that I can file the bill before the deputy council.
The deputy commissioner thought it proper. When that representation is submitted, that okay, let the Dubasi court decide.
No, there should be reasons.
The Dubasi court then decided that let it be this way or that way. Thereupon your right is under 31, and in view of 31, in view of certain judgments being passed in 31 to the effect that you have to file before the DC, then in that regard, it has to go before the DC and then to the district judge.
Your lordship, a suit has to be filed before the deputy commissioner, before the deputy commissioner refers it. If this is not a suit, your lordship will see that representation.
Where is it mentioned that it has to be a suit?
I have not.
It is not a suit, it is a civil case.
It is a civil case, but the
So you
civil
don't
case
need to
has,
file a suit.
your lordship, even means some other cases where the deputy commissioner has referred some kind of representation to the deputy commissioner, to the Dubaships. This court has also held that it must be a proper case filed before the deputy commissioner. It has to be, your lordship, the principles of CPC.
No, it cannot. It cannot because in the Dubasi,
No.
in the Dubasi court, there is no requirement of pleadings. In the Dubasi court, there is no requirement of evidence. What is required is, it is required in the interest of justice, and what is the term?
Principles of natural justice.
Not natural justice. Natural justice came later.
But
What is that? How it is to be decided? So all proceedings shall be vivavose and the Muzada, Gambura, so and so and others, so and so, And after hearing will proceed, if any, they will pronounce a decision.
Your
forthwith.
Lordship, there are cases.
So and so, within such state will file an appeal. No, and there is this one term used, no, that they will do it as per
The principles of the
principles. What is the
no,
principle?
the principles of the spirit of the IPC is applied. Your Lordship.
IPC? No
cases
IPC.
over here. Your Lordship will allow me.
No IPC.
There is, even here, your
No, Dobasi court there is no principles. Huh, Mr. Angami?
Your Lordship, this is for regard to justice.
Dobasi court, no principles. You have to file a suit against the Dobasi and come up with it. I think that is the way out. And how have the court now dealt with this? Now there was one judgment passed, I think, by Justice Sema and Justice Buddhi Habung, I suppose. As regards what is to be done as regards when a reference, because a reference was made to an order which was passed by Justice Sarto by Justice Chaudhary with the division bench. Any idea on that? No, I think there is a judgment passed to the face. Mr. Angami? Any idea on that?
Yes.
Mr.
Your Lordship,
Mr. T.B. Jamil, are you having any idea on that? What happened to the reference made? You see, Justice Sarto says in one judgment, taking into account a particular notification issued by the government, the DC judicial will mean the district judge. ADC will mean the additional district judge. So and so, whatever may be, that is there in 2014, there was a notification. And therefore held that it can be done. Now, thereupon one matter came up before Justice Arundev Chaudhary. He said that it seems to be not proper, so he made a reference to the larger bench. Now, the larger bench thereupon, I think there is a decision by Justice Sema and Justice Buddhi Habung together. I am not wrong. Any idea on this?
Yes. As far as the issue of
Pending. I think we should take it up immediately tomorrow or day after.
but as far as the number of
It has to be finished.
presents that's concerned,
I had a great difficulty in passing one judgment in view of that reference. But however, I was able to just sidetrack and come up. That was the judgment passed in the case of Mr. Iralu's case.
yes. Yes, Lord.
You appeared in that matter.
No, but in civil review number, order and judgment dated 8/6/2017, civil review number 6/2015, my knowledge is correct. These judgments is still holding their field. As far as my knowledge goes, that and they don't that is just something they have to go to the district judge.
But I think the reference needs to be finished off. But
Then
not.
thereafter a reference is there. Civil revision 5/2020. Yes.
But thereafter, I passed one judgment how I just took up because in view of the reference, I could not do anything. So the issue is there. But then also I say it out there that I passed an order to the effect that the matter would now be again sent back. It was a case, if I remember correctly. Proceedings was filed in a particular court. Not a court, it was a order of the Dobashi court. After the Dobashi court's order came in, the matter came up before the, yes, now the facts are this. There was a dispute as regards a particular plot of land between two villages or something. The matter was sent to a Dobashi court. The Dobashi court came up with a judgment in favor of somebody. Thereupon, an appeal was filed by the other side. Mr. Joe was there. He filed the appeal. When that appeal was filed before the district judge, DC, the appeal was thereupon transferred in view of that notification which has come in. which has been referred to in Justice Sarto's order. And the appeal then was transformed into a suit. Because here, that order which the DC decided that whatever may be, I think it is necessary for us to decide afresh, which is the power given under 31.
Yes.
So because of that, it became a suit, and it was transferred to the court of some district judge. When a matter came up before the district judge, the question happened without any notice, or once a notice was issued and the next no date was fixed. After 1 year or so, there is not a single order also dismissed for default. And then, because of the dismiss for default, that case which was there, the Dubasi court's order having become final, the village authorities took up steps for the purpose of throwing these people out. Then a writ petition was filed before me in that matter. So I passed to the author, then I revived the suit because there was wrong. And thereby, however, said that this order would remain in abeyance till the suit is decided. This is how it is being done. So year 32, you file it.
Your Lordship. If the.
These arguments can be very well made there. I asked for village council, he sent it to Dubasi. Now Dubasi should not have made it.
See the difference of, there should be reason as to, this is the difference of the Chief Commission. He is saying with reference to the circumstances above, I am forward here with a letter received from Sri A.
Where is that?
Page 26. This is the reference of the Chief Commissioner. Page 26. To the head Tobashi.
Okay.
And then, with reference to the subject cited above, I am to forward herewith a letter received from Sri A. William Advocate, by letter number so and so regarding the River Forest District case at Sambur village. In this regard, you are hereby directed to take.
So you filed an appeal also. What
Filed
happened?
an appeal, Your Lordship.
Then what
The
happened?
Chief Commissioner upheld the
Order of the Dubasi. Now, when did you file an appeal? Now the question is, therefore the question is, you come to the point on whether the deputy commissioner, in view of that notification of 2014,
Yes,
could have decided. Come on that.
that is what Your Lordship, I am saying.
Don't go for initiation.
The court.
Mr. Counsel, don't go for initiation. Initiation is okay. Now the question is whether the deputy commissioner could have passed that order. Where is that order?
Your Lordship, I think Your Lordship to the same.
Judgment and order. Whereas so and so, yes, so and so, where during the hearing the case was heard, read out and so, whereas the so and so remand due to ill health stated that he was not severe, he stated that he was in case was scheduled to be held on so and so binding. After carefully and no new evidence have been produced by the appellant to substantiate his case, existing evidence of bargaining supports the case of so and so. With the to produce any new substantive evidence, the office of the man ever pronounced it in favor of the land on the by a public. So he has decided it.
Yes, Your Lordship.
Now could he have decided it?
Your Lordship, no, because the initial order itself was, the initial reference of the matter to the Tobashi was given,
No,
not asked for that.
no, not that. Obviously, that I'm not.
Your Lordship, I'll take Your Lordship to the same, that's where the title of this court has been reported there.
Where?
Page 46, the in italics. Whether what are the provisions that are right in our state.
Page 46.
Page 46, yes. If your Lordship will go up some the cases passed by our this honorable court has been recorded.
Hmm.
In 1983, GLR number NOC 32, Amsori village versus Bigam village. And 1983 GLR NOC 34, Bibito Angami versus Likro or Angami. The division bench of the Gauhati High Court while examining the.
You are reading which page?
Yeah,
Page 36.
page 46.
Page 46.
Yes.
Where? Oh, yeah. Yes. What is this? High Court at the
Section
court of the. Okay. So this will be under 35 you have filed.
Yes.
No. 35 it will go to before sister, not me.
No, I have not. But
Then come under 35.
the High Court 35 says the High Court and the courts of Deputy Commissioner and his assistants shall be guided by the spirits not bound by the letter of the promotional procedure.
Yes.
Now here, some judgments have been referred to. Here in this case, section 12 of CPC, that is political to res judicata. Here, the matter has already been decided by the village council. I only want a copy of the village council judgment to file an appeal before the deputy commissioner. The deputy commissioner cannot, without passing a direction to the village council to issue the copy, so that I may be enabled to file an appeal before him.
No, what do you say? Prayer for seeking direction to Sangpur Village Council for disposal of pending reserve
Yes.
forest dispute
It is
case.
disposed. The problem is-
No, not disposed, forest
It
dispute.
has been.
Now I would like to prefer the matter to the appropriate authority without judgment or order. I cannot take the steps. I request
See,
kindly issue directives to the council to dispose of the pending judgment and order at the earliest for the ends of justice.
yes.
I request the council to issue me the judgment and order so that I could appeal before any other appropriate forum. So,
The language may be, but it is very clear in my representation. The lordship will go up to the representation itself.
so your case is, let's see your appeal. Where's your appeal memo? Appeal filed before the district judge, district DC. You have a copy?
39,
Huh?
page 39, these are the
For
draft.
that AI is bad in law, as the same. For the AI has erred in law, and so and so. For that below has Australian AI that case being a civil, the parties must deduce evidence. However, no opportunity was given. Failed to consider the respondent asserted ownership of the disputed land only on Iran and never before so and so. For that, there was no witnesses from the appellate side by simply so and so. For that, the pastor in a whimsical manner. For that, the demand below had acted in the most arbitrary manner. So,
So, your lordship,
you went into the dispute.
your lordship, I may have gone into the. dispute.
No.
But my position is that the first instance, the village council has already decided that issue. Yes. Only thing was they were refusing to issue me a copy of the judgment. But they were allowing the other party to take over the land. I filed a representation before the deputy commissioner to direct the village council to issue and your lordship.
Now why should we look into it? You file an appeal under 35. Why should we have this as a repetition? No repetition.
If the deputy commissioner has proceeded beyond the jurisdiction, then in that case, duty discernment will lie. But if your lordship is saying duty discernment does not lie, that is a different issue. But the deputy commissioner has proceeded in a manner which is not provided under the. No. I submitted a.
No, when you have
representation.
35, will be an appeal.
There is an appeal
It's a
provision also,
revision
but
under
if-
35.
But
It's a
revision
revision.
lies when the procedure as adopted was legal.
It's an appeal provision, no, where is that? High Court, yes. The High Court or the Deputy Commissioner may, on the application by an agreed party, call for a record. This is a revisional jurisdiction. 32. Has 32 come in?
It is provided that the party agrees may move such application only after availing of committee by way of appeal.
Mr. Angami, has 32 come in? It's given here, na? Some of the sections have come in, some have not. Rule 32 and 33 of the principal rules here, yeah. Rule 34, this is section 27. Rules of the payers and so on. Yes. 32 is here. Has it been notified? Thirty-two. You have to come under 32. Not 227. You have a revisional jurisdiction. Why you are exercising 227?
But this court has,
No, there's a difference between them. The Supreme Court in many cases says that when you have the jurisdiction under 115, you can't exercise 227. Why should we exercise a supervisory jurisdiction?
then your lordship may allow me to submit this for change of the
It has to be
course,
32.
it can be done also.
32, this court will look into it because 32, if I exercise, I would not go into the supervisory jurisdiction. As to whether that order is wrong or not on good conscience or fairness of justice on that aspect. The moment you are coming under 227, then obviously all other judgments comes into picture. But your first point, I'm disregarding. Rejected. This is an afterthought, Mr. Counsel.
No, your lordship.
Absolutely.
Your lordship, these are people living in remote areas. These are the people living in remote areas, villages in the remote areas.
So,
They are.
are you therefore saying that you are that,
No, your
that
lordship.
they could not get the assistance of you there because of that this has happened?
Your lordship, the thing is like this, your lordship. If your lordship may kindly consider my submission, your lordship. They have submitted the application before a duty commissioner under his supervisory jurisdiction over the village council authority. To pass an order to direct the village council to issue its judgment. The duty commissioner cannot convert it into a suit when there is no prayer, because unless there is a prayer.
Understood, but then
Your
also the
lordship, so my-
Dubashi, then also the deputy commissioner directed the Dubashi to decide the dispute.
But it was,
Wait, Mr. Counsel.
yes,
The deputy commissioner, then the Dobasi, you participate in the Dobasi proceedings.
yes, your lordship.
After the Dobasi proceedings comes out and comes with a decision against you, you
Yes.
file an appeal under 31.
Yes, your lordship. But
In the 31, you don't take a single point that the deputy commissioner could not have sent it to the Dobasi. And you decide there. And the court, the district commissioner thereupon decides it as a proceedings under 32, 31(1) and pronounce it as a judgment. There against that, you are here before this court now challenge it. Then well, look, whatever has happened. Now you see the entire thing. I only asked for a certified copy of the order, and he did not give it. And now all these proceedings happen. All these years have gone. Now kindly quash to everything because the initiation, my petition was for something. How can this court will do it? You do one thing. We can allow it, subject to cost for the entire proceedings, from the beginning. Why did you on one hand participate there? 10 lakhs?
Your lordship, if the principles of law is not applicable, several principles of law is not applicable to my case. Then what more can I say? The several principle of law is that.
Several principles,
Manner
Mr. Counsel.
prescribed.
No. Law is always perspective, one, and secondly, on facts. Here the facts are
Here the
different.
fact, yes.
Here the facts is different. Everything happened. Now you come up with a point out here on the ground that the council is here present in Kohima, had a better understanding of law, and therefore you raise this point that the entire initiation was bad. That's it. That's your submission now with the council.
No, my submission is that, no, I am saying that law has to be followed to its.
Law will be followed. Law will be
Commissioner, it has
followed.
not been followed. My position is not like that. My position is that law lays down certain procedures. It has to be followed as per the law laid down. The deputy commissioner, while acting as an administrative authority, cannot convert an representation submitted to him on the administrative side into a case. Here, that is my submission.
So therefore understood,
So,
you could prepare a fantastic appeal memo under 31, but then also you could not.
Your Lordship,
You
but
could not.
that may, yeah, but even my approaching under Article 31 Section 31 was not even necessary when the initial action itself is illegal. That is my submission, Your Honor. When the initial action of the deputy commissioner itself is illegal, there was even no need for me to file an appeal before the deputy commissioner, because if you don't know, all these proceedings are illegal. That is my position, Your Honor.
And you participated there.
I participated. But why should I say otherwise? Why should I say otherwise when the report clearly says it? But merely because I participated, Your Lordship, the law is very clear. The principles of law laid down by the Supreme Court is very clear.
No, the Supreme Court judgments would not apply.
It is very clear. Those laws say that when something is done in a certain manner, it is violated, then the entire subsequent proceedings will not validate the initial illegality. Here, the initial illegality was converting my representation into a civil school and giving it over. Secondly, it is not an appeal before the deputy commissioner. It is not an appeal before the deputy commissioner, so that the deputy commissioner can either decide to take it up as an appeal or not. So the only place where I can appeal is the deputy commissioner. And there is no appeal from the village council because the village council is withholding its judgment. This is where the problem lies. The villages, they are.
Now, let us come to section 23A.
Your Honor.
Section 23A, Rule 23A says that Lobasi henceforward shall
Yes,
try and decide such civil cases
yes,
only as may be referred to them by
yes,
the deputy commissioner or the
Yes.
additional deputy commissioner or the assistant to the deputy commissioner as the case may be.
yes.
Now, the deputy commissioner has referred it.
Your Lordship, this is as.
Does it mention that it has to be based upon it? The deputy commissioner can exercise the power
Yes, yes.
based upon an application.
Whether your, my position is, here is.
No, Mr. Counsel, you have to,
Whether the
no,
deputy
Mr.
commissioner can
Counsel,
convert a representation into a civil case.
Mr. Counsel, the question is, one has to be very careful on this because here is a case of a waiver and acquiescence on your part. You have led every order being passed against you. Now you say, then look here, I submitted a representation to so that a direction can be given by the village council to the village council to give me a copy of that order of 16/10/2002. That's your case.
Yes.
But instead of doing that, the deputy commissioner have referred it under 23A.
Yes, whether that was legal or not, that is the question here.
Thereapon you participate,
Yes,
file, give evidence, everything.
yes.
Then get an order, file an appeal under a year. After filing an appeal, you participate, don't take a ground to that effect. And the court decides that. Now you say, then look here, I only asked for that.
Yes, Your Lordship. I am challenging the
Very
deputy
good.
commissioner's reference on the matter. Here, whether the deputy commissioner can.
Now, why should we exercise 227? Why should we exercise 227? Doesn't say shocks the conscience of this court.
Your lordship, allow me some time to rectify the defect, your lordship.
What effect?
Again, I may file an application under Article 32 also, okay? No, Rule 32.
32 you
But
have to-
here, your lordship, here. Your lordship, I am aggrieved by the deputy commissioner. Deputy commissioner doing certain things. Here, in this case, it is the High Court and the deputy commissioner has competent power, so that means this applies only to cases taken up by the High Court, and lower than authorities lower than the deputy commissioner.
No, you see,
Yeah.
the deputy commissioner did not convert it into a suit. The deputy commissioner took it on itself and said that the judgment which have been provided by the Dubasi court shall be deemed to be his judgment. This is 31. This is how he
Yes.
exercised it. So therefore, your right ought to have been to come under 32
Against the deputy commissioner.
against the deputy commissioner's
Yes.
order before this court, but you did not. You come under 227. So
Yeah.
therefore, we dismiss it on that.
Your lordship may see here, under rule 30.
Let me come back at 2 and dismiss. In the meantime, I give you some time to think about.
Your lordship, I have already submitted whatever required to be submitted, but I will also submit up some decisions of this honorable court, whereby this court has said that unless the deputy commissioner, proper case is filed before the deputy commissioner, he cannot refer just any kind of application to the overseas. That judgment is also there. I'll take your lordship.
2 o'clock. you cannot proceed. And you need to challenge it on the basis that when the court thought there was evidence required, if you see the the DC's order, the court thought that the evidence was required, but you did not submit evidence.
No,
If you see
that
the
is what they
order,
are saying. That is what they are saying, but
no, whatever may
Yes.
be, when you say that the evidence is required, means you are not satisfied on the basis of that. Thereby gave you an opportunity. Once an opportunity is being given to adduce further evidence, it converts into a trial. So it should have been, for the interest of justice, a suit. Come up with that. You have a good case on that.
Your Lordship, yes, but my position is it goes way down below. Because the deputy commissioner will not be filing a case before he could not have converted it into a case. That is why he could not.
You have a difficulty in that, taking into account, you see, whatever may be, it is an adjudication being done. You have participated all along.
Your Lordship,
You never raised that issue only in the proceedings under 227. For the first time, you are raising this issue. Then, if you are raising that issue for the first time, can the court say that there was a perversity or something which shocks the court? Becomes very difficult in 227.
yes. Under 32
You should have therefore said that the DC should have converted into a suit
yes.
by exercising the
But
power
he
to
did
that
not.
effect. And these are the evidence which could have been given or not given, whatever. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that taking into account the scope of the present proceedings, which is the proceedings under Article 227 of the Constitution, the petitioner would be well advised to withdraw the instant proceedings with a liberty to approach this court under the Rule 32 of the Rules of Administration of Justice and Police in Nagaland. The learned counsel further submitted that the withdrawal of the instant petition should not prejudice the petitioner. Taking into account the above and also having perused the materials on record, this court closes the instant proceedings on withdrawal. So, liberty given to the petitioner to approach this court in terms with Rule 32 of the Rules of Administration of Justice and Police in Nagaland, if so advised. It is further observed that the withdrawal of the instant petition shall not prejudice the petitioner to again approach this court in terms with the liberties so granted herein above.
For admission, item number 16.
Yes, sir. I received the order and proposition by the United States. We run me 2% of the.
The learned counsel appearing on behalf of the petitioner submits that the state have filed the affidavit in opposition only on 26 May 2026, and the petitioner be granted an opportunity to submit an affidavit in reply. List this matter again on 26th of June 2026. In the meantime, liberty granted to the petitioner to file an affidavit in reply.
For orders, item number 17.
Yes, why the matter has come up for orders? Service not complete. Upon whom? NHIDCL has a council.
What way of instruction they give?
Okay, you are there. So service is complete. Mr. Muajami, the learned counsel appears on behalf of NHIDCL. Taking into account the above, the service is complete. List the matter again for admission on 27/2026. In the meantime, the respondents herein, including the state respondent, the respondents herein, that is, the state respondents as well as NHIDCL, shall file their affidavit in opposition on or before 17th of July 2026.
For orders, item number 18.
Yes.
Also, the IA, granted IA is for amendment of aforesaid of your worship.
What has happened
I have read it in a certain area of worship.
in the father's name?
Is it what you the appearance of the petition is also.
Heard Mr. T.B. Jamid, the learned counsel appearing on behalf of the applicant. Mr. N. Angami appears on behalf of the respondent numbers 1, 2, and 3. This is an application for correction of the credentials of the petitioner as regards their father's name, which incorrectly, on an account of an inadvertent error, was wrongly mentioned.
Worship, address.
Father's name and address on account of an inadvertent error was wrongly mentioned. The correct particulars of the petitioners have been provided at paragraph number 2 of the instant application, taking into account that the said, the correct names.
Paragraph 5, correct, this is to the correct.
No, para 2 of the application.
Paragraph 2, this one I have stated in the petition.
No, you say here, na, the correct particulars, details, address of petitioner are given here in under. Correct, para 2. Para 1 is what is given earlier. Para 2 is, you say it is to be the correct one.
See the prayer, page 6, worship.
Are you the resident of government high school or not? Petition number 1. That is it. Para 2 and para 5 is same. Yes, para 2 and para 5 is same.
Yes, your worship. And I sorry.
The correct details are given. What did I write? The correct particulars, oblique details or the addresses of the petitioners have been provided in paragraph 2. So taking into account that the said mistakes having been inadvertent errors and the correct address, correct name of the father of the petitioners as well as their addresses are required for an effective adjudication of the present proceedings. This court allows the instant application, thereby incorporating the names of the petitioner along with their details and addresses as mentioned in para 2 of the instant application. This court further directs the learned counsel appearing on behalf of the petitioner to submit a fresh memo of parties before the registry of this court within 7 days. And the registry shall make necessary changes in the cause title and update the same in the CIS. I stands disposed.
Then petition after. After 2 weeks.
Matter pertains to seniority.
Here,
Service is complete.
no. Your lordship, I have made this book for by will and cost. Your lordship is my prayer is very limited, lordship. You know what has happened? The petitioners are serving as sheets, your lordship. Now, a tentative signature which was published on 8/4/2026, inviting claims and objection. Now, the petitioner has some claims and objection on the ground that one of the senior have been placed. Yeah. Now, in the process, it has been brought to the knowledge of the petitioner that before it was disposed of, their process is on for giving promotion based on the tentative signature. So my case, your worship, is that since having invited claims and obstructions, I have filed my claims and obstruction, and this activity is cast upon the respondent. This to dispose of my claims and obstruction before acting upon the tentative signature. That is the all your worship with this.
You consider as per whatever it is.
Worship, I have a prayer, worship, my prayer is. I'll be filing them on the possible today, or in the possible day. With the matter, there is over Thursday or Friday, you worship next.
2 minutes.
Yes.
Okay. Taking into account the above, and madam, now you put it here in the main petition, huh?
In mind.
No, I is okay, I is done. Now in the main petition you write. Just list this matter for admission on Thursday.
Worship. Was for the. Much.
And Mr. N. Nangami appears for the state respondent in the main petition, huh? It's the TB Jami in my format which I put it, huh? The petitioner, TB Jami, N. Nangami first. You just take your instructions on this aspect. I'll pass an order to consider if you have not yet finished.
Yes, sir.
If you have done it, it becomes infructuous.
For orders, item number 19.
Yes,
Yes,
instruction the here on the orders, the respondents object 1, 2, and 3. Axis Bank.
Mr. Mujoy, I have added some paragraphs out there in that judgment. Have you got it?
No, I checked with the.
PIL. The PIL.
Yes, I'm yet to get the order. I've
I've asked the minister, asked the government, asked the registry to serve a copy upon you, the petitioner counsel, as well as Mr. Yangovan.
No.
The reason why I have said that, although I passed the direction, I gave a direction to this union also to make arrangements for the other districts for funds.
No.
Because I have written it out there that the state of Nagaland may not have the financial problem there. Who they have.
Yes.
And there is an availability of blood is one of the is a basic amenity falling within the ambit of right to life.
Right. Yes,
So therefore directed them to do that. So that order, I think you'll get it. And I have asked you to file an affidavit on or before 27/1/2027.
Yes.
And you give an update. If nothing works out, it can be revived.
Yes, sir. I've already informed the Department of Social.
I think this will help you.
No.
Rather than the petitioner, it will help you now to take it up with the government.
Yes.
Because for the 4 districts, Pensang, Kifre, Mon, and Ferin, they have provided it.
Yes, sir.
Now, for the other districts which are not there, let the government give you money.
Yes, sir.
I
In
think
fact, after informing the department regarding the direction of the court, though we have not got the hard copy, we are anticipating to have a meeting very soon to roll out the.
now you can take it up with the government.
Yes.
I have imposed directions upon this respondent,
Very
the
well.
union.
Very well.
They are very necessary.
All right.
And in that other matter where that also, I think you will get it today. There is some correction to that, man. It will become a long judgment of 51 paragraphs.
Lost.
That gave. but I put one paragraph out there. It's a very interesting paragraph, means it's a very fundamental paragraph.
What?
You see, it's a fundamental rule of service jurisprudence that a post can be envisaged, described, or defined in the service rules.
No.
When a post is envisaged in the service rules, it is a post in paper.
Yes.
When a post is, but that post is not, you can't do anything unless the post is created.
Great.
For that, you need a government order.
Yes.
And in that regard, the power has been given to the government under 4.
Wonderful.
And I have also said that the power to determine is a very word of wide import. And therefore, it would include not only to vary, create, abandon, upgrade, many others.
No.
Anyways, let us come to the point.
Here, I'm agreeing for, I found my document this morning, Worship. The agreement for respondent number 1, 2, and 3. This is access bank.
This is a matter pertaining to
Worship, this is a cyber fraud.
how much?
Digital Worship. No, Worship, as per the calculation, is coming to more than 5 crore transaction has been done against this account. And there are more than 10 criminal cases pending all over the country.
Of the petitioner?
Yes, petitioner.
Okay. You
The
have
last indication that the petitioner has put is 39 lakhs unaccounted money has been deposited to that account. But this is not an unaccounted. This is a cyber fraud.
cyber fraud will be somebody's money somewhere it has been
Scam. Yes.
That's cyber fraud.
Yes. No, Lordship, in fact, I've received all the records. All
You
the,
file your affidavit.
yes, Lordship.
But is this cyber, if it is there, is the police a party?
No, Lordship.
How is it possible, Mr. Counsel? You have to make the cyber people a party.
Yes, Your Lordship.
Nah. You will take that issue only. How can this court pass a direction in your case?
No, in fact, there has been a request from the criminal courts all over the country for freezing of this account because so many transactions has happened in this account.
So you
No,
should,
it's not a question of 1 to 2 lakhs. It's in terms of crores. Lordship, I have the records. All the account transactions are here. Unaccounted.
anyways, you file your affidavit.
Lordship.
Mr. M. Mujoy appears on behalf of the respondent numbers 1, 2, and 3
Lord.
and submits that he has received the instructions and would be filing his affidavit. How much time?
Lordship, at least 6 weeks because I have to send it to the main head office in Mumbai for verification.
List this matter again on 16th of July 2026.
Lord.
In the meantime, the affidavit be filed on or before 14th of July 2026. The petitioner in the meantime would be at liberty to file appropriate application to implead the officials or departments, oblique departments, who had instructed upon whose instructions the bank account of the petitioner have been freezed. Give it the liberty, huh?
No, that's right.
For hearing, item number
Madam,
20.
you just put it, service otherwise is complete. List the matter for admission, then you put Mr. Mujoy submits. Yes, Mr. Sharma, what is this second appeal?
But this security was I was sick on the day
Then what happened?
and by some other security.
Oh, by framing a question.
Yes.
And thereupon the matter, oh, I knew then that I will be coming back. Yes, tell me. Whether the first appellate court was justified in dismissing the suit of the plaintiff on the ground that in a suit seeking declaration of title over a plot of land, in absence of a description of the immovable property, the suit cannot be denied. Whether the finding of fact arrived at by the learned first appellate court that the land wherein the patta has been issued in favor of the respondent, number 1, overlaps with the patta which was issued subsequently to the appellant is perverse. One is as regards that in a suit seeking declaration of title over a plot of land in absence of a description of the immovable property, the suit cannot be decreed.
Yes.
That is one. And the second is pertaining to a question of fact, but you have to show perversity. Then it will be a question of law. I remember the facts, if I know. Just now, if I may recollect, there was a particular person concerned, your client was residing over a particular plot of land. And thereupon, after many years, you went somewhere, you came back and found him constructing a boundary wall.
No,
Not that?
you know, we agreed, the taking of a land. See parcels the, for the land of the team only. Team only was in occupation of 2.6 pieces of land. And then after him, team only, he appellate or currently appointed this amendment. And that was the show. And then we paid. The other appellate is respondent, three. He filed an application for the settlement said that this land was divided. The high cost is the land established was the 1 kata 15 years. Then he applied for the settlement officer, and the settlement officer without going through the records and sent my attachment. Then I went to the DC. DC is the contact and directed to the no, the is number, then we go to the high court. There are two messages, one is against the civil rule and another against the civil rule. If the high court fail, then you go to the civil court and get your title, get the character defense.
So you purchased it from your brother.
That's
How much is your land, Mr. Sharma?
Kolkata 60 races.
2 katha,
Six.
8 letters,
Kolkata 60 races.
16 letters. Two kathas hai. So there is a settlement order of tag number 1134 under block 9. Huh? And that is your settlement order. Now, his tag is what? His tag is different, block 9 of tag number. What is your tag number?
827. Why is the 827?
Huh?
172.
Your tag is 173.
But bottom 70, bottom 173. Block number 9.
Plot patta number
70.
17,
Yes, ma'am. Block number 172.
172. And your settlement order says tag number? Where you issue the patta? Where is your patta?
Page 169.
Page
116. After
169. Patta? Page
page 169 of the paper. And in original it is page 91.
169. What is the patta number? This is the settlement order. Block 9 under dark number 26 on periodic lease basis for the following term. So now where is your patta?
Yes.
One zero zero nine. Page 171.
Page 1.
So your dark number is patta number is 1009. Or patta dark number 1134. Okay. Now tell me, this patta has been issued to you on, let's see, it must be, can't be before that. What is the date of this document? Approved by a government letter, allotment of land. This allotment happened on of 2 bigha, 2 katha, 16 letters area under dark number Iman. So dark number 26
Yes.
was a government dark. There has to be a government dark, otherwise allotment could not have happened. So this land was allotted to you on 29/4/2013, 2003. Isn't it?
Yes.
So the moment you have taken this land on an allotment, it presupposes that the sale which was made was just a sale, unregistered sale of a government land, of any land. Maybe the sale of a possession of a land or whatever it may be. But the settlement was given to you on 29/4/2003.
Page 160.
168. And what is the date of this document is not known. Page 169. This date, what is this? 13 May. So the patta, So land measuring on periodic basis on EA has been given on 13th May. 13th May 2003. And thereupon the patta was issued. So this has to be a government land.
This time was a it was a kilometer. This time was that was
But that, no, if it has been allotted at any point of time, this allotment cannot be your basis. The entire case, if it is on the basis of this allotment, which is made by the government, you are accepting that the land was government. If you are accepting that the land is a government, if he had the right over that land, now what happens is, he says that he has a patta. Now his patta is of 17. Na? Patta is
86.
huh?
86, 1986.
What is your patta? Patta is 17
70.
of the dark number 172.
Yes.
Now this patta is, where is that patta? 194. And this patta was there of 86.
86, and my lord, before this I had purchased it, and before this, the seller for whom I purchased was issued patta in 1972.
Where is that?
Now that patta is not there, but it is mentioned in the cell, my lord.
Okay.
Page 192. That
193.
number everything is mentioned.
Okay. Now what is your boundary?
Page 93 is the regular page for the cell, my lord.
One kata 15 lessons. Of patta number 70,
Yes.
not 72.
No, patta number 17.
70
70.
of dark number 172. Okay.
I purchased this in 1985.
You purchased in the year 1985, February.
Yes. Then it was mutated and transferred in my name.
It was registered when?
Registered.
On 1/7.
Yes, ma'am. 170.
Huh?
Yes, 1 page. 118.
1/7. Registered by me on 28/6. 28/6, 1985. Certified copy was issued on 1/7. Isn't it? 1/6. So this is within the four corners of the boundary. Now, what is your boundary, Mr. Sharma? There's no boundary either in this document at page 168 or 169.
One 65.
Huh?
165.
165. This is it.
Yes.
So this is NH Road, Lotha, How. Are these connected, Mr. Imti? No, Sungirao Lotha, who is on the north of your land, is he connected with Sri Mahabeno Lotha?
Worship, my boundary is totally different from restriction on the land. It's different from this.
From this.
Namespace 166.
So then, if your boundary was different, why did you file an objection?
Objection? No. Lordship, objection, it's not this one. After I purchased it and the land was transferred in my name, I built a boundary wall. When I was there till 2003 without any disturbance, I even tried to set up a stone crusher unit. Never subjected, so I had to dismantle. In 2003, I heard that the plaintiff, because I was staying in the plaintiff has entered and was trying to build a cash house in the house. Since
That is what I said in the first thing today.
yeah, that is me, not him.
What do you mean?
This
That is what I remember.
this is the-
You were not there
Yes,
at that
but
point of
it's a
time.
different.
Hmm.
But it was not the plaintiff, that was me.
Okay.
Then I told my lord, then I said.
So it is the question of identification of the boundary,
And now, there's one more thing.
not the question of because if this boundary does not match with this boundary,
She also,
the main problem is how do you get a declaration? If it is the identification of the boundary. Problem lies there. So therefore, and more particularly, your land is bigger.
My name is
2 kathas 16 lechas. And his land is 1 katha 15 lechas. Now who is in possession?
my lord, I was there, she entered, so I filed an objection to the DC. DC says restraint, and after that, we landed out in the court. No one is there expecting. It's bounded by the boundary wall that I had constructed in 1986. So she tried to enter, and no development has been carried out since then, because it's not.
Well, there are two reports. It's a very cool. One is 8/166.
1
166.
160, yeah.
As narrated by the authority by order number 766. I have
Now,
done.
this is not done by the court.
No,
This is not in exercise of Order 26, Rule 9.
187.
Huh?
187.
187.
It was not an evidence before the trial.
Now, this is the document on which basis? This was exhibited.
No, this is after the suit, during the pendency of the suit, my lord. It was not exhibited. It's not an exhibit in the suit, in the trial, and this was also, the survey also was not examined, this has not been exhibited, has not been proved, my lord.
But then
And it was-
how does it find inside this paper book? How is it?
The appeal memo was demo. Wasn't a appeal memo. My lord, the list of exhibits will be there in page number 190, page number 98
What?
of the paper book. The list of exhibits before the trial court.
98.
That will list of the trial court judgment.
It's 186.
98. Exhibit 1. Plaintiff sale deed 83. Surveyor report. So and so of 2002. Settlement order. Treasury challan, so and so, restraining order, representation, notice, letter, spot verification report dated. What is this 7/6/2003? And that is the exhibit P15. Mr. MT, kindly see page 98.
Yes, sir.
Exhibit 17, verification report dated 27/4/2005.
Yes, this is not the one, this is page
This is it.
186, my lord, there is page 186.
This is also says the same thing.
186.
Falls under dark 26D with an area of so and so, which is currently under the occupation of Sri Wabang Jamir, as per the trace map submitted by so and so.
Therefore, the personal court has held that this verification report was based on the survey report, which is page 187.
Huh.
But this page 187, neither the survey nor this document was executed. Because this document is substantial, not the second pattern, as per the report.
Huh.
As per the report.
But this was exhibited.
This was the.
So if this was exhibited, it clearly shows that his land is outside your purview.
Well, that is the report of this person, PW2, who was examined as PW2. But he says it is based on the survey report. This report is self-verification report is based on the survey report, which is page 187. Apart from that, now, this person,
He was PW3.
PW2,
Three.
three, yeah, so sorry. And he himself says, "My this document will not confer any right to me."
No, it's okay. But be that as it may, one thing is very apparent.
Yes.
That there are four your land has been said to be occupied by one Wabang Jabir.
No, that is absolutely wrong. Lordship, this land, 72, my predecessor in interest was having it since 1972 till 1985. Because that numbers were given by law. It is mentioned in the survey. He was paying land revenue. That numbers are mentioned in the survey. Since 1972, my lord, he has been paying land revenue, which has been proven in the trial.
No, there's no,
Then-
no, Mr. MP, there's no quarrel with the proposition that you are the owner of 1 Katha 15 lectures of
Yes.
land.
And then,
Now, whether these falls within the four boundaries.
yes, no. Now, my lord, that land I have taken possession was here the boundary one.
Very well, there's no quarrel. But
There
the
was
main
something-
problem is when there is a question of boundary dispute.
Yes.
It was the duty of the trial court, instead of referring to all these things, to make a Amin commission and in terms with Order 26 Rule 9. There's a judgment of the Supreme Court in that regard. No, Pratibha Singh is different. Pratibha Singh is Order 7 Rule 3 and Order 20 Rule 6. That is a different thing. That irrespective of not, it is the duty of the court to do it. That is one different thing. But there is a judgment of the Supreme Court on the very categorically saying that when there is a question of dispute of the boundary, then the dispute should have been decided by the court under Order 26 Rule 19 by issuance of a commission. Now that commission having not been done, that is the mistake.
Yes, there is a, my lord, the plaintiff never urged for a commission even before a trial court. Never even the first.
No, it is not the question of the trial courts there. The trial court can do it by himself.
Yes, no.
It was the duty. Where Supreme Court judgment.
Now, Lordship,
Unnecessarily, the matter has been pending. Yes, this is this paragraph 4. In fact, that day only I would have disposed it of. But taking into account the trouble which me or anybody would have in writing the judgment with 15 substantial questions of law. Huh? Isn't it, Mr. Sharma?
That is why we have find this structure under order 41 to 27 and order 26 to 9.
Where? Before the trial court?
it's said,
It's okay. Now, this court would not like to do it. That power has to be given there because there will be a question of evidence. So we direct the remand it under Order 21 Rule 27. That for the purpose of deciding it, taking into account the judgment in the case of Union of India versus Ibrahimuddin, that for the purpose of deciding the suit or the appeal, it is the requirement that this court can't do it without that evidence.
Yes.
So therefore, and that evidence, that aspect is the fundamental. So for that, it is required that this matter needs to be remanded back to the first appellate court. Who will cause this thing done? Where that application under Order 41, Rule 27, which is a part of the record of the instance, shall be decided by the learned first appellate court
Yes.
and decided.
Some observation to that, I think, finds a little bit machine, but there are other aspects of the law, but this is secondary and the officials of law has been framed on. But it's, of course, it's within the discussion of the court to pass such an order. I'm not disputing.
No,
that.
Mr. Imti, can you appreciate one thing? You say that this particular plot of land belongs to this. You have the CPC. You know? You say your boundary as per the sale deed is Diffu Road, so and so, so and so, so and so. You have a trace map also, as I could see. They have produced a trace map, no?
Not to.
Somebody has produced a trace
Yes,
map,
yeah.
186 or something.
Then,
That's your trace map? I saw some trace map here. Where is the trace map?
there is the plaintiff.
Anyway, somebody has given a trace map, somebody has given.
188.
Page
188.
180.
It's whatever exists in the law.
It's okay. It's okay.
Or proofs for the law.
The 180 is some office.
188.
180.
Just that. It is the final.
This one. This is a trace map. Now, this is a trace map wherein some trace map 1971 proposal maps of soil LRS. What do you mean? Whether this was exhibited or not, this is another thing.
The documents that we are relying upon now, they'll never be for the trial court.
No. This verification report is
That is the
there.
only thing that was.
So that is there. But anyway, this verification report, it was the bounden duty of the state of the year. For the purpose. I am only sending it to the first appellate court, not to the second appellate court, trial court, because if I send it to the trial court, he will amend the prayer. But anyways, whatever may be, the issue, whatever, he may not get a declaration of his right title and interest without that. But he can very well say that the order is wrong. The order is wrong because that order says that it overlaps with yours and cancel his patta.
No. Yes. Worship, problem was given to that, to a plaintiff. When the government, when I bought the company, government found that this was overlapping, double issues, and therefore government cancelled the allotment. Well, they can see this.
Rightly so, and therefore the government has done it.
Yes.
Now the question is, when he has appeared and challenged that order,
Yes.
it was the duty of the government court to see as to whether there is an overlapping. This could have been done. It is actually a case of boundary. This could have been done by filing and by initiating a PA under Order 26 Rule 9. If he had done that, you had the authority. Once that report is given, it would become an evidence under Order 26 Rule 10. And you will have if it goes against you, you have a PA for cross-examining the commission. And thereupon come up with your facts, or you may, and then once that evidence is given, I will also have to give you an opportunity to give a rebuttal evidence. That's also one judgment is there. Or there's a scope of I think this is separate judgment with the power of giving rebuttal evidence.
Worship, if I make this for 2 minutes.
Yes.
There's no dispute regarding the title or assembly. Well, since 1986, 85, till 2003, my position, established in the trials.
Then
So therefore, that also gives me a right. Now,
you are in possession. But the fact remains, at that point of time, he is in possession later on.
In 2003, when he entered,
So when he entered, he was in possession.
he,
And it is not your suit.
it's not much.
It is not your suit. In fact, you should have filed a counterclaim. At that point of time, saying that this is my right title and interest in respect to land within my boundaries. That was not done. But be that as it may, I think this is the order while issuing the second issue. We hold it to be perverse on the ground that the court ought to have required. As regards the first, I think you can't get a declaration. Without that, and that too when it is a case of boundary without asking for that. So the first issue, question of law is answered against you. Second question of law is here. Because then one I decided one against you, you cannot then go back and amend. I know what will happen.
The amendment was also rejected, refused no appeal. An application was filed by the plaintiff.
Yes.
Asking for amendment. That was.
Of the claim. Obviously, that cannot be done. But anyway, that we cannot allow. So we have to hold it. You cannot get a title without that. And more particularly when the suit relates to it. But your purpose would be served. On the question, if you get that order set aside, your patta revives. But if you can't get the relief of declaration of your title, then what happens? Would it not affect you later on? You'll apply as a res litigator. And if it applies as a res litigator, then you will have a trouble. You made the mistake of asking for declaration of title. So what to do with that? We can't allow you, see the amendment having been rejected by this court. I can't allow you to do that there. You cannot get an amendment to that effect. Now the first issue has to be decided. You are asking for declaration of your title. Over what land also you have not mentioned. See, where is the plain?
Yes.
Huh?
Additional appraisal. Because the paper that paper gets the only. Amended paper is not released.
Okay. So this is paragraph 26 is not was the original one where you did not challenge that order.
That's then different. Well.
Have you mentioned anywhere the suit land in the plaint? Where? Wait, so and so, yeah. Anywhere you have been mentioning the suit land? Hereinafter referred to as a suit land. Any word to the effect? So have you mentioned anywhere what is the dark number in your plaint? Ah. So that will be deemed to be the suitlet.
22A, 22E. Please 24.
Here you said dark A oblique 26. So your land have been sufficiently described, may not be in the schedule. Okay.
Worship, can I just,
Hmm.
worship, in 1983, when she purchased the land, why there was no PATA, there was precautions. She said that PATA system was not prevalent at that point of time. But my lord, her own witness, PW2, says PATA was introduced 1968, and I already had PATA number since 1972. So, was the land which was I had purchased was already numbered way back in 1972. And when that issue came up, she said that I took possession in 1983. But I did not have PATA because PATA system was not prevalent. But her own witnesses said that PATA was introduced in 1968. Similarly, was the state is also saying. So these issues are there. Man.
These issues are not there. The issue which is there is twofold. He has not challenged your right. Your title, he has not challenged it. What he has challenged it, that your land is somewhere else, his land is somewhere else.
So that is true. If that is the case, she's the one who's filed a suit against me, claiming the land which was under my possession. The land which was under my possession. She filed a suit claiming that land, that was my right over that land, the best of which and my
No,
right is
she's not claiming that.
No.
No, see her reliefs.
Then
Her relief is set aside that order.
Mhm.
Second is declaration of my title over the suit land.
Suit.
Number 3 is permanent injunction.
Yes.
These are the 3. Now, what has happened is she's not claiming, saying a declaration that no right has flown upon you or your cancellation of your sale deed. He is not asked. So you have a title. There's no quarrel, Mr. Imti. You have a title. The question is as to where the land is.
No, based on the title to whom I'm occupying this land. Now, when she
Very
says
good.
that-
If you are occupying,
No, at that point of time, in 2003, after that she came, and then complaint was filed, this is a restraining order was passed, and then we ended up with the court service council in 19. So my lord, now based on that, once that land is identified, Lordship, is still 72 on the basis of the
Mr. Counsel,
this land.
no, Mr. Counsel, can you appreciate? You are claiming that you have been in possession from 1986 onwards. And she was nowhere to be seen
Yes.
for the next 17 years, 18 years. Thereupon she has come. Now, whether that is right or wrong, that is another aspect of the matter. It is not your case of having adverse possession. You are not claiming adverse possession over her land. That is not your case. Your case is simple that I am the owner of this land. These are my 4 boundaries.
Yes, and these are the
And therefore, these are the documents. So you have produced these 4 documents in support. There's no quarrel that you are the owner of this particular 1 Katha 15 lectures of land. There's no quarrel with that. But what is the quarrel out here is simple. As to whether the learned court below were right in deciding a question of boundaries without going for a commission under Order 26.
First of all, they also have to describe the boundary properly. They also have to describe the boundary properly now. Now their boundary is only on the basis of Jama Bandi, which was the draft numbers are based on the Jama Bandi, which was mentioned pursuant to a settlement order. Settlement, my lord.
But Mr.
It's not purchase, it's settlement.
Very well, that is understandable. But my question is, that document of 27/4/2015 was a part of the plaint. Yes, can you see that? It's a part of the plaint.
For 2005.
No, this one,
2005.
2005, was a part of the plaint.
Yes.
Wherein it has been mentioned that which tag number is where. His falls under A26, your fall under D26. This is being mentioned. So now, therefore, the question is the court should have done it. I'm not here to decide. I'm not going to say that you don't have a title. You have a title. I think the best option is for you to go before the first appellate court and find it out. And let both of you argue there before which place? Dimapur. You stay there. You still stay in Dimapur. Very well, nearby.
But after there's so many issues with Gauhati. And now.
No, you see the reason why I can't take it up is for this purpose. If I have to decide also in view of the Supreme Court judgment, there is a requirement of an Amin Commission. Once this Amin Commission, I'm passing that order, if I do it, appoint it, that Amin Commission has to appear because if it goes against either of the parties, then in terms with Order 26, Rule 10(3), he will have a right for cross-examining. Once he has a right of cross-examining, he cross-examines, he has a further right of giving rebuttal evidence. More particularly you. The appeal is against you. So you'll have a right of giving rebuttal evidence because he is asking for Order 41 to Rule 27 application. You have a right to give rebuttal evidence. Once you give a rebuttal, all these things cannot happen here. We don't have one box or no box. So we pass the order in 5 minutes. Let me come back. 5 minutes, this order will pass. Heard Mr. Isha Sharma, the learned senior counsel, assisted by Mr. G. The learned counsels appearing on behalf of the appellant, Mr. You are appearing for 1 and 2. 1. Appears for respondent number 1. And how can they be performer, Mr. Sharma?
State is proper, yeah.
Eh?
State is proper. Why don't you?
State and 1 is performer. How is it possible? Understood, but you are asking for setting aside an order of the states. Anyways, Ms. V. Sukrut, the learned additional advocate general, appears on behalf of the respondent number 3 and 4. At the outset, Mr. A.C. Sharma, the learned senior counsel, submitted that in the memo of appeal, as well as also in the suit, the state respondents have been incorrectly described as the performer defendants, but they contested, no? They having contested, they have retained the status of main defendants. The present appeal has been directed against, the present appeal under section 100 is directed against the judgment and order dated 5/3/2020, judgment and decree dated 5/3/2020, passed by the learned principal district judge, Dimapur, Nagaland, for short, the learned first appellate court, in first appeal number 5/2016, whereby where is the judgment?
Good.
120. Whereby the appeal filed by the respondent number 1 oblique the defendant number 3 in the suit was allowed, thereby setting aside the judgment and decree dated 24/8/2016, passed by the learned civil judge, Senior Division, Dimapur, in title suit number Civil Division Dimapur bracket, the Learned Trial Court, in title suit number 02/2004. This court by an order dated 16/3/2026 reframed the substantial questions of law in terms with section 100 bracket 4 of the Code of Civil Procedure 1908, reframed the substantial questions of law in terms with section 100 bracket 4 of the Code of Civil Procedure 1908. The two substantial questions of law which have been framed are as hereinafter, page 1 and 2. The question arises in the incident proceedings as to whether the substantial questions of law so formulated by this court are involved in the present appeal. For that purpose, for ascertaining the said aspect, this court finds it pertinent to take note of the brief facts which led to the filing of the present appeal. The appellate herein claims that she has purchased via an unregistered sale deed dated 23/11/1983 a plot of land from one T. Murray, bracket since deceased, her brother, in the year 1983 for a valuable consideration of rupees 60,000. It is the further case of the appellant that as at that relevant point of time, there was no patta system introduced when the GB of the Duncan Bosti allotted the land to her brother. She took steps for issuance of patta in the year 2002 before the respondent authorities. The respondent authorities thereupon, with the approval of the government, not the respondent before the concerned authorities. The concerned authorities, with the approval of the government, granted the patta to the appellant pursuant to a formal settlement order dated 3/5/2003. The Jamabandi of the land was corrected and the patta which was issued was numbered as patta number 1009 of Dag number 1134 under block 9 of Dimapur town, measuring an area of 2 kathas 16 lechas. This aspect is apparent from a reading of paragraph number 12 of the plaint. It is also the further case of the appellant that the appellant paid the land revenue for the year 2003 on 14/5/2003, as well as the house tax on 6/6/2003. To the surprise of the plaintiff, to the appellant, she was served with a restraining order dated 3/6/2003, issued by the defendant number one, on the ground that there was a dual allotment of the same dag to two individuals, which was a part of dag number 26 at block number 9. The appellant thereupon took various steps before the authorities, and the authorities having not received any favorable response, the appellant filed a writ petition before this court, as well as a revision application in respect to the order passed by the Deputy Commissioner, Dimapur. This court, by an order permitted the petitioner declined to interfere in the writ proceedings as well as the revision proceedings, but permitted the petitioner to permitted the appellant to file a suit. It is under such circumstances a suit was filed by the appellant, which was registered and numbered as title suit number 2/2004. In the said suit, the appellant as plaintiff sought for the following prayers, reliefs at paragraph number 20, reliefs, which are being relevant, are reproduced here in under page 25. The defendant number 3, who is the respondent number 1 herein, filed a written statement claiming inter alia that in the year 1985, the respondent number 1 herein had purchased a plot of land at measuring 1 katha, 15 lechas, from the defendant number 2 for a consideration of valuable consideration of rupees 14,000. Huh? Defendant number. Okay. From the respondent number 2. I have purchased it from the respondent number 2. The said purchase was made by a registered deed of sale bearing registration number SD 512/85 dated 1/7/1985. It is also further mentioned that in the said deed of sale, the boundaries of the land which was sold to the respondent number 1 herein were kept clearly marked, clearly described. The boundaries of the land so sold were east Dipu Road, west Pattaland, north land of Mr. Chungirao Lotha, south land of Imkong Jamir. Pursuant to the purchase so made by the respondent number 1 herein, the Jamabandi was also corrected by insertion of the name of the respondent number 1 on 21/1986. It is the further case of the respondent number 1 in the written statement that in the year 1990, the respondent number 1 took steps for setting up of a stone crushing unit. And for that purpose have also laid down an RCC foundation and machines were installed. However, the said unit could not be operationalized on account of certain complaints made by the neighbors. And under such circumstances, the respondent number 1 had to dismantle the said unit. It is the further case of the respondent number 1 that the respondent number 1 is a resident of Chanki, Changki village in Mokuksung district. And because of his preoccupation, he did not undertake any development works in the suit land except for demarcating the same by a brick wall. Full. However, on 15/5/2023, the respondent number 1 was informed by someone that someone had encroached the respondent number 1's land. On inquiry made by the respondent number 1 before the office of the district collector, Dimapur, it came to light that the respondent number that by an order dated 13/5/2003, the suit land belonging to the respondent number 1 was allotted to the appellant. And Jamabandi was also issued to her with a different patta number and a dag number. It is under such circumstances a complaint was filed by the respondent number 1 on 28/5/2003 to the district collector Dimapur. On submission of the said complaint, an order was passed on 3/6/2003, whereupon both the parties were restrained from further development of the structures on the land till further orders. Further to that, the government, by the letter dated 4/8/2004, cancelled the approval of the allotment of the land in favor of the plaintiff. First, The respondent number 1 further stated in the written statement that this court, by an order dated 23/3/2006, disposed of the revision petition as well as the writ petition filed by the appellant by a common judgment and order. The same judgment and order dated by the same judgment and order, this court directed that the title suit filed by the plaintiff should proceed according to law, allowing filed by the appellant should proceed according to law, allowing the appellant to challenge the legality and validity of the letter dated 4/8/2004, as well as the order adversely affecting her allotment. It is further relevant to take note of that pursuant to that, amendments were made to the plaint, and thereby the prayers which have been referred to herein above were inserted. And in pursuance to that, the reliefs which have been sought in the plaint referred to herein above were inserted. In addition to that, the respondent number 1 have denied to the averments made in the plaint. The record reveals that the learned trial court, and the record further reveals that the state defendants have also filed an affidavit in opposition, have also filed a written statement whereby the state respondents whereby the state defendants supported the case of the respondent number 1 herein. The records further reveal that the learned trial court framed as many as 21 issues. On behalf of the plaintiff, the appellant, 17 documents were exhibited. On behalf of the defendant numbers 1 and 2, 3 documents were exhibited. The defendant number 3, who is the respondent number 1 herein, exhibited 4 documents. On behalf of the plaintiff, there were 3 witnesses. However, the state defendants did not adduce any evidence. On the other hand, the respondent number 1 adduced the evidence of himself. The learned trial court, by the judgment and decree dated (28/6/2016), decreed the suit in favor of the plaintiff and against the defendants. thereby granting the reliefs which have been sought for in the plaint. Being agreed, the respondent number one preferred an appeal before the learned first appellate court. The appeal was registered as and numbered as first appeal number 5/2016. The learned first appellate court, by the judgment and order dated 5/3/2020, allowed the appeal and dismissed the suit. It is under such circumstances the present appeal has been filed. This court have duly heard the learned counsels appearing on behalf of the parties. Now, it is relevant to take note of that pursuant to the filing of the instant appeal, there is an application filed. There's an application filed by the appellant under Order 41, Rule 27, read with Order 26, Rule 9, and Section 151 of the Code of Civil Procedure for issuance of a commission for the purpose of taking additional evidence by issuance of a commission to measure and demarcate the land of title suit number 2/2004. The respondent number one has filed a reply. The respondent number one has filed an affidavit in opposition to the said application. And a reply there against has also been filed on behalf of the respondent, on behalf of the appellant. Was this application heard earlier? Why there is so much of underlining done? Yeah. It is apposite herein to take note of the judgment of the Supreme Court in the case of Union of India versus Ibrahimuddin, reported in 2012, 8 SCC 148. And more particularly to paragraph number 51, wherein the Supreme Court had categorically observed the stage at which an application under Order 41 Rule 27 is required to be taken up for consideration. The Supreme Court, in uncategorical terms, opined that the said application has to be taken up at the time of final disposal of the appeal to ascertain as to whether the additional evidence to which the applicant seeks is required for the purpose of passing the final judgment. Taking into account the above, this court now takes up as to whether in the present case, in the present appeal, the questions of law which have been formulated, the substantial questions of law which have been formulated are at all involved in the present appeal. Pustu. The first question of law. So in this regard, this court have duly heard the learned counsels appearing on behalf of the parties and have also perused the materials on record, including the paper books which have been prepared. Pustu. The first question of law, substantial question of law so formulated, is as to whether the first appellate court was justified in dismissing the suit of the plaintiff on the ground that a suit seeking declaration of title over a plot of land is being sought in absence of a description of the immovable property. Pustu. This court, in the previous segments of the instant judgment, have duly referred to paragraph number 12 of the plaint, wherein there is a description given to the land. In addition to that, at paragraph number 22b of the plaint, there is a further description as regards the number of the land. This court now finds it relevant to take note of Order 7 Rule 3, which stipulates as to when a suit is being filed for the purpose of a suit is being filed in respect to the immovable property, what is required. Order 7 Rule 3 being relevant is reproduced hereunder. In the opinion of this court, in the opinion of this court, a reading of paragraph number 12 as well as paragraph number 22b would clearly show that the boundary, that the land in question, the suit land in question, could be identified on the basis of the survey numbers which have been given. It was a specific case of the petitioner, of the appellant, that the land which was allotted to the petitioner, allotted to the appellant, was dark number 1134 of pattern number 109 of block 9 of Dimapur town. Also, in addition to that, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Pratibha Singh versus Santi Devi, reported in 2003 to SCC, wherein the Supreme Court had categorically observed that it is not only the duty of the plaintiff, but also a duty is cast upon the court to do the needful in respect to, for the purpose of ascertaining the boundaries, if the boundaries could not be ascertained on a mere perusal of the plaint. In this regard, this court finds it relevant to refer to paragraph numbers
70
and no, another one. Give it to me. Fifteen. 17. 15 and 17. 15 and 17, which are reproduced hereunder. Under such circumstances, in view of the law laid down by the Supreme Court in the case of Pratibha Singh, Supra, it is the opinion of this court that the first substantial question of law so formulated by this court is involved in the instant appeal. The second substantial question of law pertains to as to whether the learned first appellate court whether the findings of facts arrived at by the learned first appellate court in respect to the patta in respect to the patta issued in respect to the patta issued to the respondent number 1 overlaps the patta of the appellant is perverse or not. There is no quarrel with the proposed settled principle of law that a patta, if the finding of fact is perverse, there's a perversity in the findings of fact, it is a substantial question of law. The issue, this court, having perused the materials on record, finds it relevant to observe that on one hand, it is the claim of the plaintiff out here, plaintiff, oblique the appellant, that he had been granted a patta in respect to a plot of land at measuring 2 katha 16 lectures. Covered by dag number 1134 of patta number 1009 of block 9 of Dimapur town. On the other hand, it is the case of the plaintiff, the case of the respondent number 1, that he had purchased a plot of land covered by dag number 172 of patta number 70 of block 9 of Dimapur town. The order which have been challenged in the suit dated 4/8/2004 is on account of an overlapping of the land of the plaintiff, of the land of the defendant respondent number 1 to that of the appellant. And as such, as there was a dual allotment being made, the order dated 4/8/2004 was passed, thereby cancelling the patta in favor of the appellant. It is the case. It is well settled that when there is a dispute as regards the boundary, it was the necessity of law that the learned trial court or the learned first appellate court, having the power, or the learned trial court or even the learned first appellate court, which are courts of facts, ought to have appointed a commission in terms with Order 26, Rule 9, to ascertain the boundaries of the respective lands, and on the basis thereof ought to have decided the suit. This proposition, the said proposition, is supported by the judgment of the Supreme Court in the case of Sripat versus Rajendra Prasad, reported in what? SCC has not reported this? Huh? No. I don't rely on the Supreme Court. Once I got this Supreme once, so I relied it and then I had a big problem. So better off I don't rely there. in Sripat versus Rajendra Prasad, reported in 2000, bracket 6, Supreme 389. And reported in 2007 is equals to JT 2000, bracket 7, SC 379. Wherein the Supreme Court observed, when there is a serious dispute with regard to the identity of the land in dispute, the court's duty, it was the duty of the court before decreeing the suit should have got the identity established by issuing a survey commission to locate the plot in dispute. Paragraph 3 and 4 of the said judgment being relevant is reproduced hereunder. In the instant case, it is seen that the learned First Appellate Court arrived at the finding of fact as regards the overlapping of the land of the respondent, number one, to that of the land of the appellant, without issuing any commission, and thereby the basis on which such opinion was arrived at is not a basis on which such opinion was arrived at. And as such, the opinion so arrived at as regards overlapping, as regards the finding of fact pertaining to overlapping, was without material evidence. This caused a perversity in the said findings of fact. Considering the above, it is therefore the opinion of this court that a second substantial question of law is involved in the instant appeal. Next. This court further takes note of that although an application has been filed under Order 41, Rule 27, read with Order 26, Rule 9, and Section 151 of the Code of Civil Procedure 1908 before this court, but taking into account that such evidence is required to be, that evidence would have to be, taking into account that taking into account that there would be a requirement of an issuance of a commission under Order 26, Rule 9, and further, upon submission of such report, which would become a piece of evidence, parties have a right to cross-examine the commissioner. And in addition to that, the party against whom the party also would have a right of giving rebuttal evidence, and the said and further that the evidence in record is not sufficient for the purpose of disposal of the appeal, it is the opinion of this court that this is a fit case for remanding the appeal under Order 41, Rule 23A of the Code to the learned First Appellate Court, that is the learned court of the civil judge, court of the principal district judge, Dimapur, for disposing of the appeal. First, disposal of the said appeal by in terms with the following directions. The learned First Appellate Court is directed to issue a commission under Order 26, Rule 9 for ascertaining as to whether the plot of land belonging to the appellant is the same plot of land which have been is the same plot of land which have been allotted to the respondent number 1 hearing. Huh? Yours main person was allotted,
The main person is.
which the respondent number 1 claims to be his land. In other words, as to whether dark number dark number 172 or patta number 70 of block 9 of Dimapur town falls within dark number 1134 of patta number 1009 of block 9 of Dimapur town. Next. Upon submission of the report by the commissioner, the same report would be an evidence in terms with Order 26, Rule 10(1) of the Code. The parties would be at liberty to file appropriate applications in terms with Order 26, Rule 10(2), seeking a right to cross-examine the commissioner to the extent permissible in the law. The learned First Appellate Court thereupon shall take a decision, thereupon shall proceed to decide the appeal on the basis of the said evidence, taking into account that the suit had been pending for the last. In addition to that, or should I exercise Order 41, Rule 25, keep the appeal pending? Ask them to take that and come back. And thereafter we'll finish it off. Huh? That evidence is required. Once it is being a certain matter is over.
But the evidence that is recorded and considered once.
That is over. There shall be no further evidence required.
It is better to give an opinion on this when we go to the open.
So then I frame in this additional issue and ask them to decide this issue and revert back and dispose it off. That is better than to reopen anything. I think that would be better off. Thereupon, the appellant shall, the learned First Appellate Court shall dispose of the appeal preferably within a period of 6 months from the date of appearance of the parties. This court further takes note of that that further তার উপর একটা লাইন লিখিব taking into সেইখিনি দিয়াৰ পিছত for disposal কৰাৰ আগতে হা this court would not be in a position to take up all these things and as such directing the year for taking up this. Accordingly, as this very issue is pertinent, is the very aspect is very pertinent for the disposal of this dispute, this court formulates an issue whether dark number 172 of Patta number 70 of block 9 of Dimapur town whether dark number 1134 of Patta number 1009 of block 9 of Dimapur town falls whether any part of the falls within the land of the respondent number 1 bracket defendant number 3 আকৌ আৰু এটা ব্ৰেকেট দি দিব the respondent number 1 herein bracket দিব appellant in that first appeal number so and so which is covered by dark number 172 of Patta number 70 of block 9 of so and so. ঠিক আছে? The learned first appellate court is directed to decide the aforementioned issue only by issuance of a commission in terms with the learned trial court shall decide the aforementioned issue by issuance of a commission under Order 26, Rule 9 of the Code for ascertaining as to upon the said report being submitted by the commissioner, the learned trial court, learned first appellate court shall further proceed in terms with Order 26, Rule 10. This court further grants liberty to both the parties to adduce any further evidence if so required. On the basis of the above, the learned first appellate court shall decide the appeal afresh. But before that, I have to also pass an order. No? The judgment and order is set aside. Judgment and order is set there, shall decide afresh the appeal in accordance with law. Preferably within a period of 6 months from the date of appearance of the parties. Next, the parties having already appeared, or the parties being present before this court are directed to appear before the learned first appellate court on 13th of July 2026. You don't have summer vacations in the trial court? No. On 6th of July 2026 for further proceedings of the appeal. Has the records come here? No, no. The records, the registry shall return the records to the learned trial court, first appellate court, and ensure that the said records are available before the learned first appellate court on or before the date so fixed herein above in that regard, if the registry may also employ the services of a special messenger.
For hearing, item numbers 23 and 24.
What is this, Mr. Joe?
Actually, this is a challenge against the orders passed by the local.
Lokayukta?
Yes, sir.
Challenging the government of the law.
Recommendation of the recommendation of a Lokayukta.
No, we are saying that it's not, it cannot be termed as a recommendation, Your Lordship. Because positive sanctions have been issued to the state government, Your Lordship.
Whether the power is not there.
No, Your Lordship.
If I remember the Lokayukta Act, the
It's only.
recommendations are to be given. If they don't comply with, then again pass some directions. But it is otherwise recommendatory in nature.
Yeah.
Then in both cases, same.
Yes, Your Lordship.
Say what? As he moving separated, so he waited, but he thought that matter would not reach him.
Oh, yes, yes. Here the timing is still what?
4:30.
4:30. See, 15 minutes is there. She's serious to do the matter.
So, Lordship.
So you can start. We can finish tomorrow.
Yes, Your Lordship.
Yes. What is the direction? Let's see.
Lordship,
Page,
69.
order,
Lordship, kindly.
Honorable Upalukaigo.
Mr. Lordship. Page 69. Lordship, kindly come to the. Read the first paragraph, Your Lordship. By letter dated 3/24, the Commissioner and Secretary.
Which writ petition you are referring to? 33, no?
33,
Okay. Page 69.
69.
Okay, order. Who is the Lokayukta here? Who is the Lokayukta here?
My lord, Opal Lokayota, he died.
Huh?
He is no more.
He died.
The one who was already is no more.
Okay.
I am Lima.
So you're paying for dead person?
Yeah, for the department. Look at responsible for.
Okay, so let's see your directions.
Lordship, when you first read it, page 69.
Ah.
First paragraph, Lordship. Find out.
By letter that commissioner had written to the Lokayukta to investigate the case of seizure of cash of so and so. The seizure was made to the public function of so and so. From the examination of records, what said, so and so, the following facts are given. Then what happened? Where's the direction?
Then, Lordship, when I come to the same paragraph in the Nagaland law, I may not read, Your Lordship, because here it is stated that the facts have been established, Your Lordship. It stated that facts have been established.
Where?
Lordship, page 69, Your Lordship.
Hmm.
If you
The
Lordship,
Nagaland-
The Nagaland lawyer registered a case.
And so and so conducted a preliminary inquiry. The seat carried out and so. From the Iman, the following facts are established. Then,
Thereafter, page 75.
uh,
The last paragraph, Your Lordship.
despite the denial of so and so, Lokayukta seat had established that the deduction has been made by the DPO of the so and so from the beneficiaries on account from so and so. Voluntary given of so and so. We'll continue. And as such, the permission of the state government is not requirement, and that the investigation will continue as such. The Lokayukta investigation is concluded here with the recommendation. So and so, along with so and so. so and so are made accomplices under section so and so to be competent witnesses. Case of the so and so who have denied any deduction of so and so, all these documents, records are released to the focus system. So, what is wrong?
Next, again, your lordship, this is followed by another order, your lordship, which is at page 77.
Of the case in party so and so, so and so. Then,
Then after your lordship, page 84. 84 last paragraph. The exciting Nagaland may establish the following on permission of the integrity. Next. Thereafter, at page 85, your lordship.
the CBI has turned down the request of local directorate to hand over the investigation to them on the grounds of arrest of Jitendra Gupta so and so. And as such, the permission of the state government is not requirement, and that the investigation will continue as per local. Then,
So your lordship, it says that whether it will be in the interest of public, in the interest of public to continue the service of the officer's name. Now your lordship, what we are saying is that no matter cannot pass such an order, your lordship. Whether to retain a person in service or not, that should come after the outcome of the disciplinary proceedings or after a criminal case, your lordship.
what? No,
This your lordship.
no. You have been suspended.
I have been put under suspension, your lordship, but since.
So you are challenging the suspension.
Lordship,
Are you challenging the suspension?
no, I'm not telling you.
Then why are you sad? It is recommendatory. We'll say that this is only recommendatory matter and it's finished.
No, your
Yes.
lordship, another point, your lordship. In terms of Nagaland law, whenever upon an inquiry, your lordship, on the basis of an inquiry, you a complaint, there should be a recommendation. Now, if you lordship may interpret what the recommendation would be, it would be either to hold a disciplinary inquiry or to register a criminal case, your lordship. Now, in my case, your lordship, disciplinary proceedings is already there, already registered, and a criminal case is already there. So what we are saying is that there is no scope for another inquiry by Nagaland law, your lordship. So the Nagaland law was.
Your state of Nagaland is so fair, there is no problem. So you have to engage the Lokayukta for something. You are paying him some amount,
No, we are saying that
isn't it? Mr.
should.
Huh? So therefore, in spite of there being a criminal case, in spite of there being the disciplinary proceeding, there was no necessary for the Lokayukta to do anything. But anyways, the Lokayukta is functioning. What will the Lokayukta do? They got a big office out here. Huh? Isn't it?
Yes.
So, your lordship, let me say, please, your lordship.
Show me the where is the Lokayukta? Yes, show me the powers.
Section 8, my lord. Section 8 and section 25, maybe the 25.
You got this.
Section 8 and 25. Can you give me?
That is the power. But what is the investigation? Matter not subject to investigation. Any action in respect of which a formal and a public inquiry has been ordered under Inquiries Act. Any action in respect to commissioner shall not investigate any complaint involving a grievance made after the expiry of the period of 12 months, limitation from the date on which the action complained. Any complaint so and so, in the case of involving a grievance, nothing in this act shall be construed as empowering the Lokayukta to question any administrative inquiry, except this so and so. Provisions relating to complaints procedure. Now, were you in part of it?
Lordship.
Were you a part of this inquiry?
No, Your Lordship.
You were not informed.
No, report was not given to me, Your Lordship.
Did you participate in the inquiry?
I was examined by the police officer.
Where you participated in the inquiry?
Lordship, also my one wrong is that the Upper Act himself has not examined me. Only the police officer has examined me. And based on the report of the police,
No,
this order was passed.
In this proceeding, were you being informed how the investigation was carried out by the Lokaयुक्त or not?
Upper has not done any investigation, Your Lordship. It is on the basis of report of the police. The Lok Akta has passed an order, Your Lordship. Upper Lok Akta has not, I have not been subjected to any process under Upper Akta. I have specifically said it in my petition also, Your Lordship.
So the principles of natural justice have been violated.
Yes, Your Lordship.
So that's it. Over. What is the scope of the order pass? Reports of the if after investigation of any inquiry involving a grievance, the Lokaयुक्त, as the case may be, satisfied that such action has resulted in injury to the complainant or any other person, the lawyer shall by report recommend to the authority concerned that such injustice will be remedied or the competent if after investigation of involving an allegation is satisfied that such allegation is substantially either involved, he shall by report in writing communicate his findings and recommendations along with relevant documents, materials, and other evidence to the competent authority concerned. In the case of public functionary other than Chief Minister shall examine the report forwarded to it under subsection 3 and without any further inquiry take action on the basis of the recommendation and within 90 days from the date of receipt. The Lokaयुक्त shall send his report in regard to a complaint against the Chief Minister area within his recommendation to Governor area. If the Lokaयुक्त or if the Lokaयुक्त of the case may be satisfied with the action taken and proposed to be taken on his recommendation between 1 or 3, he shall close the case and the information will show. Okay, so therefore he will make a recommendation. He'll make a recommendation. And in terms with the recommendation, without any further inquiry, the competent authority shall take action. Okay, so that is the power. Now, if no action is taken, then they will have to resort to 25(5). And if that resort is being taken, 25(5) is already there. If he is satisfied, Lokaयुक्त, he will close the case. If not satisfied, then what will he do? He shall close the case. But where he is not satisfied and if he consider the case so deserved, he may make a special report upon the case to the governor and also inform the competent concern and the complainant if any. So therefore, the scheme, I dealt with one Lokaयुक्त matter before earlier. There's some judgment that in the single bench, Mr. S.S. Day was appearing. I forgot the name, I only remember the lawyers. S.S. Day. Okay, so there he was saying about the recommendation. Other side, Mr. T.B. Jameen was appearing.
Yes, sir.
Reports. So what I said here, however relevant to take note that the provision here do not show the Lokaयुक्त in terms of have the power to act as the police station or the officer in charge of the police station. The powers which have been are purely recommendatory in nature and on the basis of are cast upon public function or the computer to take approval. In the instance, we've seen that for more than a month, that submitted charge sheet and on the basis thereof the proceedings being so and so is pending trial before the court of so and so. I watched this item. So and so do not empower the Lokaयुक्त to arrest Lokayukta, no power to that effect. Now, what has the Lokayukta done? It will be just recommendatory. And if he is not satisfied, under 25(5), he may send it to the governor. And the governor is not satisfied with his report, matter ends.
But in the order, your lordship, the local as a whole, that the evidence has been established, proved, established.
But that will
What
be
is it?
whatever Lokayukta say, because you see, there's a reason why. Power of investigation has been given to the Lokayukta. If that power is being given, he has to give a report. Now, once he gives a report, he has to say, because the chief minister or the competent authority shall proceed on the basis of a recommendation without a further inquiry. So if he doesn't give the finding, how is it possible this can happen?
But this order was passed on the basis of the report of the police, your lordship. I was not subjected to any process before the local itself, your lordship.
So therefore you say that this proceeding was done ex parte without you being present. Your right under section 12 has been violated. That's a different aspect. But not on the basis that this is here. They have to say so. And what is the effect of the recommendation? You are already suspended. You are already disciplinary proceedings had already happened. Your criminal case is already there.
Already ongoing.
So what is there?
Your lordship, all this, your lordship, it might have consequence on me because it might influence the other cases, your lordship.
No,
Because
the others,
already,
I can very well close it on the basis they're saying that it is merely recommendatory and it is only for the competent authority who can act. And this order recommendation cannot influence the authority. The disciplinary proceedings can be very well. They may be influenced. There's no quarrel. This is a material which can be looked into by the disciplinary proceedings. They can. Unless you establish that coming under 12, the recommendation cannot be taken into consideration. So the entire recommendation is bad. But as a criminal, obviously, they cannot be bound. So you have to develop your case on the 12.
lordship, if other hold that illegality has been committed, I have been without any trial, your lordship.
Trial
Yes,
is
violation of
trial not
principle.
necessary. It is investigation.
Not by the local lordship again, because I was examined by the police, and based on that report, this order was passed.
Understood. You see, if you see the Commission of Inquiries Act, Commission of Inquiry Act says the commissioner has the power to appoint somebody to carry out the functions which the commissioner can do. This is section 5. Now, similarly, here also, the investigation will be done by somebody else. He has to just oversee and on the basis thereof make the recommendation. Now, he has made this recommendation. Yes. Therefore, you say that investigation, well, however it was done, or the investigation, all these things have been done. And I was not kept in the loop. They should have at least issued me a notice by the Lokayukta before making the recommendation. Develop your argument on that. Or was any notice issued to you? By the requirement, by the
By the
Lokayukta.
SIT, yes, but not by the local, by the SIT.
No,
yes.
SIT you said no. But the Lokayukta has to do, because he makes the recommendation. Improve your case, we'll have it tomorrow. I don't want to spoil it. Everybody's here that they say that I sit till 4:45. In Gauhati, I sit till 5. That's a difference.
No,
Tomorrow or Friday, Thursday, whichever you want.
what is it?
Thursday?
Sorry, Thursday, I want to take my wife to Gauhati for legal review.
Okay, then we do it tomorrow then. After Mr. Takamasu's matter.
No.
Hearing remains unconcluded, at least the matter tomorrow. At 2 p.m.
No problem.
Huh? What indeed? The matter tomorrow for final disposal. In time order pastor shall go.
So,
football appointments